Discover Bank. Discover Bank versus Donna Balenc, 2403981. Is anybody here on these?
Hold on 1 second. Hey, by chance, does anyone remember the name versus him? Oh, do we? I know. Oh, perfect. Okay.
Is Jennifer coming in or?
Well, okay, perfect. Thank you. So they're in a breakout room right now, Judge, and Jen said
Okay.
she's showing the video. So these they're not even ready yet.
Okay.
So everything's on extended.
Paul Stano, doing business as Charm Real Estate LLC versus Brian B. Stone. Oh, boy. Might as well go off the record.
We're off the record.
Wow. Good morning. What case are you here on?
Myself, Your Honor?
Yeah.
Okay, yes, I'm here for Luis Morales, I'm the interpreter,
Oh,
and he's present here in the Busher.
okay. Let me just,
That's the 9 o'clock.
that's a what?
That's the 9 o'clock.
I don't see his name on here. Oh, okay. So that's scheduled for 9, and as soon as they get in here, we'll call you, okay? Thank you.
And that's the gentleman here.
Okay.
Yes.
Jennifer, are the parties still in there on Discover Bank and Balenc?
No, it looks like plaintiff's attorney is back out. I'm trying to get Miss Balenc out right now.
Okay. Go back on record.
She's out now.
Okay, Discover Bank versus Donna Balenc, 2403981. Ms. Balenc, you have to start your video and state your name, please.
Donna Balenc.
Good morning, counsel. Good morning. How are you?
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of plaintiff, which is now Capital One successor by merger to Discover Bank.
Right. So did you two talk and resolve this?
We talked, we have not resolved that if Ms. Balenc is still working with a debt settlement company. I am not showing that we've received any offers or anything from them. And I, again, told her, and not again told her, that came out completely wrong. In our discussions, I advised that, you know, if the court grants the summary disposition and judgment gets entered, she's really on the clock at that point in time, and she needs to get her debt settlement company motivated to get a hold of us.
Well, I'm ready to go forward with the motion. I'm sorry, ma'am. There's nothing I can do. Go ahead, counsel.
Thank you, Your Honor. This is an action on a credit card account. Originally, it's Discover. Since the initiation of this action, Discover merged with Capital One, and they have continued under the Capital One name. But the statement, there was really no factual issues. Defendant acknowledged in her answer that she had the account. She did identify a balance that existed at the time that she engaged the debt settlement company. The statements we have attached show the full balance owed of $9,152.53. We're also asking for court costs of $249.50 for a total requested judgment of $9,402.03. We're also asking for interest pursuant to MCL 600.6013, subsection 7, at the contractual maximum rate of 13% per annum from the date of the filing of the judgment.
Ma'am, anything you would like to say?
I'd just like to say that I'm doing everything that I can with this company that they told me they've done their part, and apparently they haven't. I just retired and I'm receiving Social Security at this point. So that's, I mean, I'm not sure what to do, but I'm going to get a hold of them again.
Yeah, the problem is these out-of-state companies, and they're not licensed to practice law. And I don't know what else to tell you. I feel bad for you, but there's nothing I can do. I'm a grant plaintiff's motion for summary disposition. There's no genuine issue. As to any material fact, judgment will enter in the amount of $9,402.03, including the court costs of $249.50. Maybe you can work out a payment plan with Mr. Best. That's a reasonable one. Nobody wants you to go bankrupt here. And, but Mr. Best is going to send that judgment to me for my signature, and I'm going to sign it, okay? If you want, you can file a motion for installment payments, and I'll set up a payment plan that's reasonable for you, okay?
Okay, I'm not sure how I would do that, but
Well, you can come up to the courthouse here and file a motion for installment payments.
okay.
How much can you afford to pay per month, ma'am?
Well, as you know, I'm on a budget. I do get a small pension from school bus driving and then my Social Security. So I mean, it's not a whole lot. I mean, I could, you know, it sounds pretty chintzy, I know, but like 25 to 50 bucks a month would probably be the most that I could afford, because I still have a mortgage payment, obviously, with other bills that you have to have, you know, pay at this point. But I'm hoping, I really am hoping that I can get a hold of this company and we can work something out within a certain period of time that they're going to give me.
Okay, well, I'm going to go ahead and grant their motion. If you decide you want to file a motion for installment payments, you can do so, okay?
All right, thanks.
I sincerely wish you well. Good luck to you, ma'am.
Thank you.
Thanks, Mr. Best.
Have a good day, everyone.
Two. Paul Stano versus DBA Charm Real Estate versus Brian B. Stone, 2502300. Good morning, counsel. Your appearance?
Yes, good morning, Your Honor. Mark Kiaz on behalf of the Charm Real Estate LLC.
Yeah, we just adjourned this for the issue of money judgment, and I'm going to conclude you're not entitled to one. I'm going to go ahead and I'm sorry I had to come back. I really am. I just wanted to double check something. They've changed these rules so many times since COVID that with the second mailing, I wasn't sure if they were going to consider that to be personal jurisdiction or not. But at any rate, can you just prepare an order it says the issue of money judgment is preserved and send it over to me. You can refer to the prior judgment, possession judgment having been entered on such and such a date. Hearing having taken place is to whether or not the plaintiff is entitled to a money judgment. And it is hereby ordered that the plaintiff is not entitled to a money judgment at this time, but the issue of money judgment is preserved. Okay, if you could just send me that, I'd appreciate it. Sorry again for having you come here.
No problem, Your Honor. Again, yeah, I looked, I didn't see anything that changed, the requirement of personal service. But a quick question for you. We have not received a copy of the possession judgment, and I looked online, it didn't show that it had been entered.
You know what? I was on vacation last week, and I will get to that today. My apologies.
No, I appreciate that very much, Your Honor. And again, thanks for this hearing. Thanks for the information. You have a great day.
You too. Thanks a lot. Bridgewood versus Devin Vanner, 2502429.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf.
We are on the record in the 13th Judicial District. This is the District Court. We are on the record in the 13th Judicial District. This is the District Court of Butler County, Kansas. This matter comes on for our Monday misdemeanor docket, this July 7th of 2025. First on our list that I will call today will be the Love case with Attorney Watts. Is Dean Love here? On the record in 2025 CR 98, State of Kansas versus Boyne Dean Love II. Gerald Revere for the state, James Watts for the defendant. Good morning, Mr. Watts. Is your client here?
Good morning, Your Honor. I spoke with my client approximately 15 to 20 minutes ago. I know he would have been here. I'm looking through the list of Hollywood Squares folks here and see if I can find him. Boyd, is that you? Right.
Yeah, it's me. I'm seeing you guys fine, and it looks like it's okay on my end.
Is your name on your screen?
Oh, Motor Jeep Play. I don't know.
2024. All right.
Oh,
So,
there he
Mr.
is.
Watts, I believe I see his picture. I'm not sure he's moving to indicate he's with us live.
Well, Judge, I see a Moto G Play 2024, but I don't have any video, but I do have audio.
Well, let me see. Maybe I'm looking at the wrong Moto G. Wherever you are, I need you to click on your video, which would be the red icon with the camera, and also to click on your audio, which would be the little red microphone with the line through it.
My audio, my video is on. Let me see.
Your Honor,
Yes, Jim.
it looks like it's a connection problem.
There it is.
Can you guys see?
I see a frozen picture of the person I think is you and a crackly voice that might be your voice. The clerk indicates it's a connection problem, maybe. I don't know if you could move to a better position.
I've got good service. I'm on Wi-Fi. I don't.
All right, well, you're coming through better now. So I think we'll go ahead and proceed. Mr. Watts, have you any announcements at this time?
Your Honor, I have in front of me the file in this case. We filed an entry of appearance June 9. As of right now, and I checked my discovery file as well to see if there was a discovery that had been downloaded or uploaded. We hadn't downloaded yet, and I haven't seen it. I have in front of me a charging document which alleges a summons and a charging document which alleges domestic battery. I've not seen any discovery at all. So I'm going to ask to set this over for 30 days until I can get some discovery from the state. What I have at this point is merely a charging document.
This sucks.
All right, Mr. Love,
Yes, ma'am. Yes, Your Honor.
I would probably put it a little different way than you did, but yeah, it's kind of, here we are about going on our 4th month since first appearance, and Mr. Watts has entered and we do not have discovery. And the county attorney has gone to this trouble and probably expense of getting this system that's supposed to make everything wonderful, but seems like every time I turn around, there's a discovery issue. So, what was that?
I refer to it as the Chinese server.
The Chinese server? No comment. All right, so at this time, you are charged, as you know, Mr. Boyd, with that 1 count of domestic battery, having rude physical contact with a family member or dating person on February 2nd of 2025. As you also know, this is a Class B misdemeanor. You have your attorney, and we're here for our second court date, no further than we were in April. Well, a little further, I strike that. We do have the attorney and he does have the information. So yes, we have made progress. Mr. Regier, does the state have any position on anything concerning this?
No objection, Your Honor, insofar as a continuance is concerned. This is a case that appears to have been filed by my colleague, Ms. Norris, so I cannot speak to the current status of this case at this time.
Can you make a note to make sure that anything and everything necessary is done to get discovery to Mr. Watts? As you know, Mr. Watts does a lot of work with your system, so I'm sure he knows it as well as any defense attorney. So whatever we need to do to get that discovery as soon as possible.
I will put a note in the file, Your Honor.
Now, the problem is, of course, anytime I have to grant a continuance, it's going to be a ways off. And, well, unfortunately, my phone is not one. So, the next available date, Mr. Watts, is not until September 22nd, which isn't as far off as some of my dates would be. So do you want to try that September 22nd, or do you want me to try to find something sooner?
That date is fine, Your Honor.
All right. And I'm going to show this as a joint continuance because the state does not have all of the discovery to the defense attorney. The defense attorney is asking for that continuance because of his entrance in the case. All right. So we'll continue the defendant on his bond, with the bond being $1,500, posted April 25th. And the bond now includes, Mr. Love, the condition that you reappear September 25th at 9 a.m. Is there anything else from either party we need to take up?
Not from the state, Your Honor.
I don't believe so, Your Honor. Thank you.
All right, then we'll be in recess at this time on the love matter. Thank you. I now see we have Crepens on the record in 2025 TR 520, State of Kansas versus Joel Matthew Crepens. Please announce appearances.
Jared Regier on behalf of the state.
Mr. Crepensek appears via Zoom with his attorney Keith Edwards, who also appears via Zoom.
And Mr. Edwards, how does your client wish to proceed?
Well, Your Honor, fortunately, we have received discovery, but I need to meet with Mr. Crepensek to go over it. The September 22nd date, I think, would be a good, that would give us enough time to get everything sorted out.
All right. I trust if he needs an alcohol and drug evaluation, it would be done by then. If you have a plea agreement coming, it would be done by then. Hopefully, since that is so far out, not suggesting that you do those things, but if they're going to be done and in order. So September 22nd, state having any objection to that?
No, Your Honor.
All right, continued at the defendant's request to September 22nd, 9 a.m. All right, I will continue your bond, Mr. Crepens, until September 22nd at 9 a.m. You must be here at that time. And is that Jay Crep? Is that your client?
Yes, ma'am, he's here. Yes.
He's waving his hand, yes. All right, if there's nothing further, we're in recess then. You may go, sir, both of you.
Thank you so much, ma'am. You have a good day.
You too. Do we have any other defense attorneys? Oh, yes. We'll take up the Porus case on the record in 2024 TR 3214, State of Kansas versus Ivone Porus. My apologies, I'm sure I'm saying that wrong. Jared Regier for the state is the defendant, and attorney Alec Nguyen here. Alec Nguyen.
Your Honor, I show that that hearing was canceled.
All right. Mr. Regier, do you show that as well?
Your Honor, if the court is on the record in this case, what I would tell the court is it does appear.
Well, I'm not, but I will. I'm not sure if I am or not. But I am on. Yes, I am. Go ahead. I'm on the record in 2024 TR 3214.
Thank
State
you.
on Porus. Go ahead.
Your Honor, based off of my review of the file, it would appear that a journal entry dismissal without prejudice was filed with the court approximately 2 months ago on May 12th.
One moment. Yes, and the clerk has removed that from the docket as indicated. Thank you both. We'll be in recess on that matter. I don't believe we have any other defense attorneys other than Mr. Patterson, do we? Very well. Who is in the county jail, please? Is that by chance Mr. Linville?
Yes.
All right. This is a show cause. Have you visited with Mr. Patterson, sir?
Judge, can I have a brief breakout room with Mr. Regier and the CSO?
Very well. They have two CSOs. Are you both here on this case, or one of you, Ms. Teal, Mr. Smith? Ms. Teal is. All right. If you'd please put Ms. Teal and the defense of the attorneys in a breakout room, Jen. We'll take a brief moment for that. And while doing so, is Victor Ernesto Ortego here?
Yes, I am, ma'am.
We are on the record in 2024 TR 2975.
Your Honor,
Yes.
I may interrupt. We do not have a prosecutor right now.
Oh, he went into the breakout room. Thank you. All right. Mr. Smith, which case are you here for? Ryan Smith?
Your Honor, I'm here for a revocation hearing on Jeremy Moore.
Okay. Thank you.
I'm thinking, feel the duty to ask the party to those to subpoena some which can send
He wants to subpoena medical records because his client was shot in this shootout. However, that's not a disputed issue. It's on video that he was shot at. And that also that he was in an altercation prior to the murder. So I just don't see anything that would be gained from this. And I asked Joel over the weekend if he could articulate anything, and he could not.
But you interrupted. My client comes in a broken cheekbone, which I've heard anything. Maybe about the bullet. But I feel it's my duty to ask for 30 days, and it was 2 years ago. In order to subpoena.
What difference will it make?
I don't know. It may be something, maybe something mitigating. It may show. It's hard on the video to see how badly he's been beat up. And this might shed some more light. It shows him being beat up from a distance. And the jury would see that, but it's hard to make out because someone is showing really who the players are, who's getting hit.
Okay.
I think the medical records will be, it may be helpful. And they may not, obviously.
And a monkey could jump out of my ear, but it may not. I mean, there's nothing that's certain. I mean, everybody in this room can articulate maybes and could be's, but this thing's 2 years old. We're moving forward. Cordell Howard.
We got paperwork. That's a plea.
We'll take that in a minute. German Selenus.
I think Mr. Burbank is signing him up right now.
Of what language? What language?
Spanish.
Okay.
I believe one's coming.
Okay. Okay. Kaylin Hicks then. Kaylin Hicks. Yes. Nobody say anything.
I'm not ready.
Why not?
First of all, I've got a Rule 106 motion on file for alternate service and Dr. Hazel. I've also filed a motion.
What have you done about that? It's 2 years old. What have you
Well,
done?
I just got the case a month ago.
He did. He just got hired in just a couple of months ago, and he's been
Why?
crying.
Why did that happen so late?
Oh, man, got to ask them to get the money from a court of the so I need to have alternate service.
What do y'all say?
I don't have a problem, Judge. I don't think it's gonna matter much, but he does.
In order to establish.
All right,
I would think it would be ineffective, and also I filed a motion for an expert witness. It asked approval for funds for an expert witness on mental health.
Okay.
That's also, I'll need to get a ruling next.
Oh, okay, it is a reset, so we can.
But can I have a hearing set on those two motions, or if the court will just?
Yeah, all you gotta do is ask about those kinds of things, though. I mean, we're
If I send you
15 minutes into the docket, and I'm just finding out about that. That's not fair to this judge, you know.
Well, I sent you.
You gotta alert me. Stephen Matlock. Yeah.
I've got subpoenas out. We're ready if we need to get on that one, but I'm expecting to go on the case in front of it.
I'm ready if they're ready. I mean,
To Jose Sanchez.
That's a plea.
Philip, is it Yellot?
Yellot. Yeah. I've been told by both defense lawyers, it's an agreement judge to put.
Is that right? All right.
State co-counsel, I'm second chairing this.
Good. Maybe you learned something.
Yeah.
You can teach old dogs new tricks.
Julio Alende.
Okay.
Thank you. Armando Martinez. Mr. Brown.
Last week, we made an offer. We thought that might have been accepted over the weekend. He rejected it. Mr. Laird was on vacation. So
I didn't get an expert from Austin lined up because I thought it was going to be a plea according to Mr. Burbank, but we need one more reset on it.
Okay. Otherwise
it's going to be a trial. It's a simple trial.
All right. Then we're getting ready. It's going to be rolled around very quickly.
Yes, sir.
And there are no deals. We're moving forward.
We're ready. Yes, sir.
All right. Thanks, sir. Ellis Tatum.
Trial. Ready. Stay ready, Judge.
That's third. Behind Dixon and Matlock. Christopher Kelly.
we are ready, Judge. If we are not reached, I do have a motion for a bond.
Your fourth. Dontrell Jones. Mr. Reynolds.
We're ready, Judge. Stay ready, Your Honor.
Abner, that's five. Castro.
I need a little bit more time on that one, Judge. I gave Mr.
Oh, I'm sorry. I would love to give him more time, but I was advised by that gentleman right there that he's subbing in.
Oh,
Good luck.
Do you have something in writing in that?
I was asked from the defense to track down our victim, and I haven't had a chance to respond to that request yet.
Okay, we're gonna roll it over one more docket. Okay, can you be ready? Daniel LeBlanc.
I've got multiple hostile witnesses under subpoena. If I could have
Any other kind?
If I could have a date certain, like in a special setting to coordinate my witnesses, that's fine. I think Mr. Phelan's in a special session, a special session.
I think here. Okay, obviously, it's. Yes, sir. Going to have to be specially set, but it'll be specially set on a date and it will be tried first.
Yes,
what
sir.
date is that?
I was.
Yes, sir. Second trial day.
I can.
Second trial day.
That's been
No deals.
That's right.
Y'all had enough time.
We can do something in August.
I've got a vacation letter.
What?
I got a vacation.
For when? All of the month?
Well, I think not the first. That's all. I think it's the last 3 days.
First part of.
There you go, sir.
But you'll have to look at Mr. Phelan.
I'll make you available.
You're worrying about him?
I'll leave under subpoena.
I'll make you available.
He's first part of August.
First trial off in August is August 11th.
Let me check.
What's that?
I pull up my vacation letter. Can do this on file. I've also filed a motion on this GPS. He wants to, he needs to, as far as employment goes with word edge.
Pretend that you pretend that.
One thing at a time. Let's get the trial date so we can get a trial and stay.
On vacation August, through August 2nd.
Okay, the first 3 months.
What's the docket? What's the trial docket?
August 25th. This is the following docket after I was.
Set for 20, especially set August 25th.
as far as the GPS reference, can he do the national file?
Let me look at it. Let's get this docket done and so I can go to those other miscellaneous things. Ray Savant.
If it's not, if he doesn't take it, then we're.
6. Jerome Marks. Mr. Wilkerson, Jerome Marks. Anybody know about Mr. Wilkerson?
I know we've been talking about this case, Judge. I think he was gonna ask for a reset, but not to speak.
Okay, he's 7. Wyman Clover.
It's me. Let me, I'm gonna try to.
Today?
Yeah, I'm gonna try to move that one today. Let me hold on, Clover.
I got wait till the last minute. Robert Glasper. What are you doing on this? It's a burglary of villains. We don't, generally, we don't try these, but anything's possible. Angela Bell. David Grove. Angela Bell.
Yes, sir. I was told you was out in jail. I went out there last night and they lost it.
I don't show her in custody, actually. I don't show her in custody. Angela Bell?
Okay, Judge, if I could have 5 minutes.
That's you, ma'am? You're Angela Bell? She's not in custody. She's standing right up there.
Yes, sir.
In the jail.
If I could have 5 minutes.
Who told you they were in the jail? She was in the jail there. How long have you been on bond out of the jail? A year.
Yes, sir. She's been out for some time.
Okay.
And they said she was out though.
Terry Warren.
He might be, I don't know. Oh, basically.
Terry Warren. That's Mr. Adams. Langston.
In the back, Judge.
Yeah. He took off with me. Tanisha Coleman. Who stayed on Tanisha Coleman? It looks like it says just DA.
Yes, sir.
We ready on it? I've got 2 or 3 other ones ahead of that. I'm ready on it.
You're fine.
I'm saying
We all need to get ready because it'll roll around pretty quickly. This is Ricky Turner. Ricky Turner.
Okay.
And Ricky Turner, John West. That's your client.
I had a couple, so,
Ricky Turner.
ready on that one, you're like, we also skipped one of the ones up above, Kendall Abraham. That we didn't have.
I put a line for that. Somebody.
We're ready on that one. You're on.
We're ready to. Me and Hannah been talking about a couple weeks on this one.
It may have been the one above it. I'm not sure.
Definitely ready on that.
On Abraham. Yes, what did we say on Tom on Abner Castro?
That's percent, Judge.
That was the one.
Yes, sir.
LeBlanc. That's how you need for that.
Okay, so here's the lineup. We got number 1 is Jeremy Dixon, 2 is Stephen Matlock, 3 Alice Tatum, 4 Christopher Keller, 5 Dontrell Jones. 6 is Kenro Abraham, 7 Ray Savant, and
That's a plea now.
7 is Jerome Marks. And that ought to do it. The rest shall be. Todd, you've got something on Glassfield, right? Maybe. Is that right? Is that what you said?
Keep running. Yeah.
Okay, anything in the queue right now?
Oh, yes, sir. Cordell Howard.
Cordell Howard, please.
Ma'am, Your Honor.
I'm third. I'm gonna be next door for a while and then I'll be back.
Cordell Howard. First, John West. And Mr. Eckert.
And I'll be square,
Computer from here's what I mean. Open. Did you get upstairs? To bring it down here, or was it? Checked it out. Some give you make sure.
Right out there.
Yeah.
And you also. This is my office. Is that a different person? Do we really know that?
Sure.
There's small.
Yeah, she's trying to say hi. And she didn't say it.
I read over the how many shots you fired. She beat when she got. Yeah. Yeah, I know they can say that. No. I'm saying reduction. Yeah. Needs very. That's what I said.
Mr. Howard, please raise your right hand. Swear on oath to self you got. You have your record. This is right here. Watch out.
We're allowed.
I've got three cases. What are we doing?
We're gonna plead on one and dismiss the other.
Which one?
The. Let me see, you can see about, can tell you it's the first number. Plead on 9-5.
Twenty-two 39095 is now called the State of Texas versus Cordell Howard. That's you, present. With Mr. West, your attorney and the state's attorney does the defendant waive a formal reading of this indictment and the arraignment here. We proceed in a summary fashion.
Yes, Your Honor, please.
In summary, this indictment alleges that on or about January 7th, 2021 in Jefferson County, Texas, you committed the second-degree felony of sexual assault of a child younger than 17 years of age. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced 10 years in prison. And two other cases would be dismissed, 22-39096 and 22-39097. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
I'm guilty.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the content of the State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer. All of this is true of state, so help you God, as that says. State's Exhibit 1 is made a part of the record for all purposes. Also, as a result of pleading of guilt and finding of guilt in such a case, you are going to be required to register as a sex offender. Do you understand? Failing to properly register as a sex offender can result in further criminal charges against you, and they are felony offenses general. And as Mr. West talked to you about your obligations in that regard.
Yes, sir.
Is there something on the pad that where he fills out a document? Is there something on the pad where he fills out?
That sex offender registration on the tablet.
Okay.
So,
That needs to be
yeah,
done.
John just goes in.
You know, right after this.
I see it. I'll send it over.
It must be done. And then the court reviews it for proper form. Is a pre-sentence report waived here?
Yes, please.
If nothing further, I'm going to follow this agreement and find Mr. Howard, you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second-degree felony of sexual assault of a child younger than 17 years of age. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. Do you understand what has happened today?
Yes, sir.
Fill out.
I'm trying to get tablet on the tablet. I was the problem.
Tablet, and then the court will let me know when it's done so I can review it and I go over it with him. Also, you've got two other cases
They're going to be dismissed, Sean.
to be dismissed.
Yes, sir. They should. Through any moment now.
I have 22-39096. I just dismissed. And 39097, all this part of Cordell Howard's charges, and that case is also dismissed as part of the agreement for his plea of guilty. Kevin Lane? Yes. Jose Sanchez? He's in best. Does he speak English? He does. Okay. That makes two. Yes. Yes. It's easier, isn't it?
Yeah, so the court is aware I originally had pled the co-defendant to a cap, and the court, co-defendant, and the court after a sentencing hearing ended up given that particular co-defendant an opportunity on deferred adjudication probation. Both of these defendants are similarly situated as far as the offense occurs, as well as their history. So I'm doing what I think is fair and putting this defendant on the same.
What you should do. All right, 23 CR 88 is now called. The state of Texas versus Jose Sanchez. You and Mr. Sanchez?
Yes, sir.
Present with your attorney, Mr. Lane, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does.
In summary, we're just going on paragraph 1.
Yes, sir.
This indictment alleges that on or about January 8th, 2023 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault by causing serious bodily injury to the victim, the complainant in this case, by kicking the complainant with your feet and punching him with your hands about the head and body. Do you understand what you were charged with?
Yes.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
The agreement's been reached in your case. You would be pleading guilty, not found guilty, placed on deferred or unadjudicated probation for up to 10 years, fined $750. I presume there's restitution here?
No, sir, not for this particular case.
That's correct.
I understand he's got injuries.
It says serious bodily injury.
There's no way to account for those injuries. The victim is incarcerated in federal custody. And
they're treating him?
Yes.
Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to the second-degree felony of aggravated assault? Guilty or not guilty?
Yeah.
Are you pleading guilty voluntarily and because you are guilty? Show you what's marked as State's Exhibit on there. Did you sign that document voluntarily? Did you just understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the vice parents' confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yeah.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived here.
It is by defense, Your Honor.
Yes. I'm going to follow this agreement, if nothing further, and I'm going to find that you, Mr. Sanchez, are pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But the court is going to instead defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be a fine of $750. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow these terms. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 20 years in prison. Also, the court is going to find affirmatively that a deadly weapon was used in the commission of this offense, and that is the deadly weapon is your hands and your feet by kicking and striking the defendant. Do you understand what has happened to them?
Yes, sir.
Anything else? That is all.
Thank you.
Thank you, Judge.
What, does this have a motor? It is today.
He uses this main as his motor.
They have another color. They were both in there. It goes with the. Merge.
No.
Everybody ready? Next? No?
Judge, Angela Bell, that's what my bond is, and I think she's ready for her now. Is it for, that's how it's on the second page, close to the bottom. Yes. There are other theories of some time. Yes.
There is no Angela Bell on the second page. Don't have one on the third page.
Okay.
Oh, this is the trial docket, off the trial docket. All right. What is it? It's on the trial docket.
Ms. Bell,
What are we gonna do?
she says she wishes to go to trial.
Well, that's why she's on the trial docket.
Yes, sir. Well, she just ready to go to trial.
Okay, well, she's in the queue with others.
Yes, sir.
Well, we got
Just
6 others. Well, they're either a trial or a plea. There are no others. Yeah,
For her, she does not wish to plead.
that's why they're on the trial docket. All right, who's that? Tom, do you have something on a plea?
I do. I have Mr.
Who is it?
Selenus. We're just finishing it up as the interpreter.
Okay.
I also have a motion in front of you with Mr. Keller. You want?
Okay, who is it? Did you say Selenus?
Yes,
Do we need an interpreter in this?
we have one.
You have?
Yeah, here's that one.
All right.
Okay, Selenus, you forward. So we're going to be pleading to one will be dismissed, correct?
Going on, I just want
One
through the number.
There's the one that's getting.
There you go.
There's not one over there. I haven't almost.
We have another one, Judge, who dies.
It's quote in the woods, so.
Woods.
Yeah.
Is that
Should be
the
signed.
announcement or?
That's, well, that's on their notes.
I've got Selenus in the queue. Where's he?
Mr. Selenus. Looks good. Okay.
I'll need him to come in front of me first.
This is the more. Everyone's still missing, 9-0.
Yes. Pick up your right finger.
Anything on something you got here lined up?
He is a US resident.
You'll see him.
I need to do that. That's topic. Okay, and do that, make sure you put in the case that says that you don't have.
Are you German, Mesa Selenus? Do you speak English?
English? No.
Are you a citizen of the United States?
No, no, that's
How long have you been residing in the United States?
Said I don't remember very well, about 12 years.
Then you don't speak English?
No.
He said I mainly work.
So do I, but I speak English and Spanish and some other, but I mean, what's your status towards citizenship? Are you trying to gain citizenship?
Primero quiero estudiar, pero ya que tengo más tiempo.
He said I would need to study for the test, but I would need a little more time to do that.
12 years isn't it long enough?
12 años no son tiempo suficiente.
Es que siempre he trabajado y como no, apenas mis patrones me dijeron que agarrar un estudio para ellos darme después más algo.
He said I really only work here recently. My bosses have told me to go back to school and become a citizen so that I could advance at my place of work.
How much do you make in dinero?
Me pagan por día, me pagan
I get
300.
paid 304.
Yeah.
I get paid daily 304.
304 per hour
$200
or per day?
Por día.
Yeah,
per day.
304 per day?
Yes.
How many-
4 por día.
How many days do you work? A
¿Cuántos días
week?
trabajan?
5?
6, a veces 7.
6, 7.
You're working almost every day?
Casi todos los días trabajo.
So you make $305 a day?
So hace $305 al día. Yes.
Apenas me dieron esto hace como un mes.
So I started making that amount of money about a month ago.
And you work almost every day?
¿Trabajas todos los días? Yes.
A veces que llueve,
Sometimes
no,
if it rains or
pero ahorita como hay mucho trabajo, sí, trabajo un solo día cuando
there's a lot of work right now, so we work every day.
cuando descansamos más es como de noviembre a febrero.
We said our downtime is November, sometimes February.
Do you know how much money that is annually? A year?
Eso es-
Do you know what your income is here?
El año pasado se 74.
So the last year we made about 64,000.
1,000. No, that's if you're working 7 days a week, you're making $110,000 a year.
So todos 100 días.
Sí, dile que porque apenas me subieron esa cantidad, pero le pagaban 220.
He said they recently gave me a raise. Prior it was like
Congratulations, you're still making $110,000 a year. And you don't speak English? And how are you doing on your taxes? Are you paying your taxes?
Sí.
Yes.
Who's taking care of that?
¿Quién hace eso?
If you don't speak English, how do you do that?
Voy con una señora que hace taxas y habla español.
I've been with a lady who does taxes and she speaks Spanish.
Mm-hmm. Okay. Does the defendant waive a formal, first of all, interpreter? You have an interpreter here since the defendant primarily speaks Spanish. And what is your name, ma'am? And Ms. Burge, you've translated here in this court before.
Judge.
And can you tell us a little bit about your history in Spanish and English fluency?
I translated in this courtroom and other criminal courtrooms for the past couple of months.
How long have you spoken Spanish?
My whole life.
And English?
My entire life.
Yes,
Judge.
you're bilingual?
I am bilingual
Yes.
fluent.
And you have, the court recognizes this lady and does a fine job. Do you swear and promise that you will properly translate from English to Spanish, the language that the defendant understands, and from Spanish, his answers, to English so that the court reporter and all of us can understand, and the record shall show what he is stating in answers to the questions. Will you do that accurately? So help you God.
Yes, Judge.
Lawyer, thank you. And you are German Selenus.
Yes.
Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
He does, Your Honor, we can, and just for the record, Judge, I use this interpreter to go over the paperwork, upon his signing, so.
Mr. Salinas, have you understood all that the interpreter has stated to you? Do you understand what she is stating to you? And if you don't understand, ask her to explain it to you. Is that all right with you?
Yes.
All right. In summary, this indictment alleges that on or about December 3rd, 2020, in Jefferson County, Texas, you committed the second-degree felony of sexual assault of a child younger than 17 years of age. Do you understand what you were charged with?
Yes.
This is a second-degree felony, which means you face imprisonment for a term of not more than 20 years or less than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you are facing?
Yes.
An agreement has been reached where whatever sentence shall not exceed a cap of 5 years in prison. So you are looking at really two options. Confinement in prison for no less than 2 nor more than 5 years imprisonment if I follow this agreement. Also, you could be placed on deferred or unadjudicated probation, which can be up to 10 years in length. Is that your understanding of your options?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
Also, as part of this agreement, another case 22-39990, which is another sexual assault of a child.
It's the same,
A different date. Yeah. That second case will be dismissed as part of this agreement. Is that your understanding?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this second-degree felony of sexual assault of a child? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Voluntarily.
I show you what's marked as State's Exhibit 1. Did you sign that document? Did you understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
no objection, State's one.
Without an objection, it is admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, it states, so help you God. State's Exhibit 1 was made a part of the record for all purposes without objection.
No objection.
Pre-sentence report is going to be needed here.
Yes,
We're going to order a pre-sentence report. We will return back on August 7th, 9 o'clock a.m. and take up the matter of sentencing at this time. You're going to see the probation officer, sir? And begin the pre-sentence report.
May he be excused?
Yes.
Steve. See, I also filed these sets with you.
Okay, you'll go over that with him at the time sentencing.
And I haven't, when we go out, I believe it be, and I can be.
Who is it?
Darren White.
Is it ready?
Yes.
Darren White, please. Thank you for your participation there. You get the participation prize.
Huh?
You get the participation prize.
Yeah, it's short for PP.
You know, it's an honor working with you, bro.
It's actually non-30 dollars. Is that on the non-30 dollars?
Yes.
Who is it?
There's more coming too.
Yes, Darren White. But you? Show right up.
Mr. White, I need you to come. Break the 5 million? We could, you know, record, it's on. Everybody says flat, right there on the box. You get up one more time? Sit flat, right there, don't roll it. Yeah, yes, sir. All right.
We now call 24 CR 1379, the state of Texas versus Darren White. You or Mr. White present with your attorney, Mr. Burbank, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does, he may, huh?
In summary, sir, this indictment alleges that on or about May 30th, 2024, in Jefferson County, Texas, you committed the first-degree felony of murder by striking the victim about the head and body with a bat. Do you understand what you were charged with here?
Yes.
If convicted of a first-degree felony, you face a term of life in prison or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment is applicable for a first-degree felony of murder? An agreement has been reached where you would be pleading guilty, found guilty, sentenced to 40 years in prison with credit for time served as allowed by law. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this indictment, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection, stage one.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it.
Yes.
You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
We have to waive, Your Honor.
I'm going to follow this agreement if nothing further to add by anybody. I'm going to find that Mr. White, you pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of being guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty of this first-degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. And the judgment shall reflect an affirmative finding on the judgment that a deadly weapon, namely a bat, was used in the commission of this offense. And I'm looking, so it's clear it's a baseball bat that was used. Okay. All right. Anything else?
No.
That is all. Thank you. Yeah.
Okay, I'll do it on the sixth and right now.
Okay.
I don't see Mr. Kelly or Mr. Kimler. Those are two that I know have pleas already ready.
We got Ray Savant is.
That's Kimler.
Where you going?
He might be back now.
Mr. Walker, on your matter, are y'all ready on something?
With Judge, Garcia.
Where is this?
This is Garcia. Trying to get that issue with him, Philip Yellot, that'd be a plea this morning.
Okay.
That wife's doing computer paperwork.
Sorry to hear that. No. He hasn't
I had a couple of things.
shoot off a rocket or something, the way he manipulates the computer. Could start a war.
We should go, but I didn't have a couple of just first done this morning.
Okay, let me know.
Thank you so much.
Yeah.
He's
Hey, John. Whenever you're through, we've got Ray Savant.
I was signing.
Okay. Okay. Is Savant ready?
Yes, sir. That's him.
That's you, sir?
Yes, sir.
Okay. How do you pronounce your?
Savant.
Savant. Okay. Because I had friends whose name was pronounced both ways out of Groves.
Okay.
Sorry, just having you in front of me in the front. Mr. Savant.
Go right over there.
Here, please. Mr. White, can you tell me where- what you're talking about?
That's
Is that your right hand plant?
Just off the
Flat
top.
block right there?
Yes.
And place it right there. Yeah. No front judge.
How many cases? Was it 2 or 3? So far, 4.
Well, they're dismissing one.
It's 4 cases?
They're dismissing one.
I'm asking, are there 4 or 5?
Well, 4, but they're dismissing.
Okay. Okay.
The state, you know.
And
Yeah,
we got
yes.
3 in the queue, plea queue, correct?
Yes, sir.
All right, we got 598. 1355,
Yes.
1356.
No, this is true.
And I presume then 1357 will be the one to be dismissed.
The state jail.
1357? Yes, sir.
You are Ray Edwards Savant,
Yes, sir.
present. And Mr. Kindler, your attorney and the state's attorney, does the defendant waive formal readings of these indictments and arraignments here? Can we proceed in summary?
He does, we may, Your Honor.
We're just going on the first paragraphs in each of these?
Yes.
Looks like we got a 3rd-degree felony and then 2 second-degree felonies.
Correct, Your Honor.
All right. In 24 CR 598, in summary, sir, this indictment alleges that on or about February 15th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with there?
Yes, sir.
Third-degree felony means that you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you'd be pleading guilty, sentenced to 5 years in prison to run concurrently with the other cases. Is that your understanding of the agreement? And one case will be dismissed.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to hold that one in suspense. Go to the next two, 1355 and 1356. And does the defendant waive formal readings of these two indictments? Can we proceed in summary?
He does, we may.
In summary, each of these, and can we take them up together?
No objection.
Each of these similarly allege that on March 6, 2024, in 1355, and on or about February 20th, 2024, in 1356, in Jefferson County, Texas, you are charged on those different dates for illegal possession of a controlled substance, namely methamphetamine. Second-degree felonies in each case. Do you understand what you're charged with in those two cases?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000 in each case. Do you understand?
Yes, sir.
Agreements have been reached where you would be pleading guilty in these three cases. Found guilty, sentenced to 5 years in prison to run concurrently with each other. Is that your understanding of the plan?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead then in each of these cases? The 3rd-degree felony of evading arrest or detention with a motor vehicle in 24 CR 598.
Guilty.
And in 24 1355 and 1356, the 2nd-degree felonies of illegal possession of controlled substance. You formally entering pleas of guilty in each of these cases.
Yes, sir.
Are you pleading guilty in each case voluntarily,
Yes, sir.
knowingly, intelligently, and because you are guilty of what the indictments allege in each of these cases?
Yes, sir.
In each of these cases, I'll show you what's marked as State's Exhibit 1. Did you sign those documents
Yes, sir.
voluntarily, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 in each of these cases is tendered into evidence without objection admitted. State's Exhibit 1 in each case similarly states that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with your attorney in each of these cases. So help you God, it states.
Yes, sir.
States Exhibit 1 is made a part of the record for all purposes for each case without objection.
No objection.
Pre-sentence reports are waived.
So waived.
I'm going to follow these agreements if nothing further and find in each of these cases, Mr. Savant, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each of these cases from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. In each of these cases, you are hereby sentenced in accordance with these agreements to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years imprisonment. Each of these cases shall run concurrently. Do you understand what has happened today?
Yes, sir.
We got the dismissal on the bank.
Yes, sir. I submitted it. Stand by.
The state jail. Yeah, so everything's wrapped up.
And 24 CR 1357 is before the court. There's a motion to dismiss in that case as part of the agreement. In all of these 4 cases pending, I've signed it. That case is dismissed. Do you understand what has happened to Lisa? Oh,
Thank you.
do better. Okay.
Nothing to yell at this lady.
Here. Who's next? Kelly. Philip Yellot.
Yes, sir.
That is for ready.
Your name.
Think that you were. Where's it? You can I need it darker than that. Is it black right now? Which reality?
Mr. Walker, show hand.
I now call 2 cases, 23 CR 489 and 23 CR 490. Each the state of Texas versus Philip Yellot. And you were charged with the state jail felonies in theft in each of these cases. And you were here with 2 attorneys, Mr. Walker and Mr. Kimmel. I believe we call that a gaggle of attorneys. More than one. And who's going to handle this? Mr. Walker?
I will.
Handle the, you'll be lead on this one? Good. Mr. Kindler, would you like to a pen and some paper and take some notes?
I'll write your honor of the bar stuff.
When this, show you how Mr. Walker does it so that you can.
He doesn't need a pen and paper, Judge. I can assure you. I'll agree.
All right. What is, we've got a state jail felony, but we have obviously a second paragraph with numerous convictions, which first and second paragraph will make a state jail felony. It looks as though in each case. And then we go on to allege in the third paragraph, a prior conviction in 2001 of a state jail felony. Then thereafter, a conviction in 2006 of a state jail felony, and finally another state jail felony. And these are criminal mischief and illegal possessions of a controlled substance. So are we just going on paragraphs 1 and 2? Or
Need 3 as well, Judge, because we're doing a 3rd degree punishment.
okay, so Okay, let me understand this then. You're stating that 1 and 2 are a state jail felony. Paragraph 3 is another state jail felony. That enhances it to a third degree?
You need 3 and 4.
Yeah.
I apologize, Your Honor.
And because they're in sequence, it doesn't matter as long as they're state jail felonies. The most you
they
could
don't.
pull out of prior state jail felony convictions would be third degree felony punishment.
Correct.
Okay.
And they don't need to be secret.
All right. All right. Do you understand what's going to happen? You're going to be pleading guilty to a state jail felony, but it will be punished as though it were a third degree felony because of the punishment, because of the prior convictions. That's where we're looking. Okay. In summary, and we're going to take these up together, if that's all right.
Yes,
Without objection. In summary, Mr. Yellot, the indictments in 489 and 490 in paragraph 1 in each case similarly allege that on or about September 2nd, 2021 in Jefferson County, Texas, you committed the state jail felonies of theft, and it was involving a property of a value of less than $2,500. And that would not be a state jail felony, except paragraph 2 goes on to allege that you have
It needs to be the
8. You have 8 prior convictions of thefts. 2 or more prior theft convictions enhance any kind of a theft to a state jail felony. So even if you steal a pack of gum because you have 2 or more prior theft convictions of felonies, then it bumps it up to a state jail felony, which normally carries with it no less than 180 days up to 2 years in the state jail and a fine up to $10,000. And that would be similar in each case because the 8 prior convictions are alleged in each case. Do you understand what you're charged with in paragraphs 1 and 2?
I do.
But it doesn't end there. Paragraph 3 goes on to allege that you were convicted in 2001 of criminal mischief out of the 128th District Court of Orange County, Texas. That's alleged in each case.
No, sir, it's not, Judge. Just to make things complicated for you.
I'm looking at paragraph 3, and paragraph 3 states in each case that he was convicted of the felony of criminal mischief, a state jail felony on June 25th, 2001 in cause number A22R in the 128th District Court of Orange County, Texas. Wow.
Judge, I see it in cause number 23, DCCR 0491. I'm looking at 24 DCCR 1368, and I did not see that
No, I'm
prior.
looking at 489 and 490.
The agreement that I signed, Judge, should be on 491 and on cause number 24 DCCR 1368. 91 and 68.
Well, hey, I'm railing on 489 and we're not even dealing with that, right?
That's right. It's important, Judge, that we do it.
It is important.
Well, it's called, the 24 cause number is the one that involves restitution, so the paperwork should have been sent that reflects that, Your Honor. And I apologize that I didn't catch that earlier.
Hold on.
You did. We signed the right thing. No, you followed exactly what I got there. I was real quick, I think there's two new cases. The line started. You understand? I know they double check. I'm just saying I did.
Looking around. Look at it.
All right, 24 CR 1368 along with 23 CR 490. These are the two cases where he's pleading guilty to. And again, I went over on 490 that this can't be more confusing. 491 is this one. And 1368 is this. The other two are to be dismissed.
Yes, sir.
23 491. Again, the defendant's waiving formal readings of these. Can we proceed in summons?
Yes, sir.
In 23 491, this indictment alleges that on or about October 7th, 2021 in Jefferson County, Texas, you committed a state jail felony of theft. And it states in paragraph 1, theft of a value of less than $2,500, which is not a state jail felony. But paragraph 2 goes on to allege 8 prior theft convictions out of district courts of Jefferson County, Texas, Orange County, and Harris County, Texas. And those thefts of paragraphs 1 and 2 as alleged together constitute a state jail felony. Do you understand? Yes. Okay. Paragraph 3 goes on to allege that on June 25th, 2001, in the 128th District Court of Orange County, Texas, you were finally convicted of a state jail felony of criminal mischief. And finally, paragraph 4 goes on to allege that on September 21st, 2006, in the Criminal District Court of Jefferson County, Texas, you were convicted of illegal possession of controlled substance, a state jail felony. So that means that paragraphs 1 and 2 constitute state jail felony, but 3 and 4 will constitute an enhancement because of the prior convictions on different dates to third-degree felony punishment, which means you're facing no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. You understand?
Yes, sir.
In 24 CR 1368, in paragraph 1, you were charged similarly as the previous case 491 with on or about February 11th, 2024, committing theft of a value of less than $2,500. But paragraph 2 goes on to allege 13 prior convictions of thefts out of Jefferson, Orange, Harris, and Hardin County, Texas. Paragraphs 1 and 2 constitute a state jail felony, but paragraphs 3 and 4 allege in this 24 CR 1368 that on December 10th, 2007, in this court, Criminal District Court of Jefferson County, Texas, you were convicted of illegal possession of controlled substance, a state jail felony. And paragraph 4 goes on to allege that on May 9th, 2013, out of the 230th District Court of Harris County, Texas, you were also finally convicted of the state jail felony of illegal possession of controlled substance. So paragraphs 1 and 2, as well as the previous case, constitute a state jail felony. 3 and 4 added into this equation means a state jail felony punished as though it were a third-degree felony. So again, in that case as well, you were facing no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're charged with and what you were facing?
I do. That.
All right, agreements have been reached where you would be pleading guilty in each case, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for thefts. And 2 cases would be dismissed that are pending, 490 and 489. Is that your understanding?
Yes, Your Honor.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, Your Honor.
Hold on. In each of these cases, how do you plead to paragraphs 1 and 2 in these indictments? Guilty or not guilty?
Guilty, Your
Are you
Honor.
pleading guilty voluntarily and because you are guilty?
Yes, Your Honor.
And paragraphs 2, 3, and 4, which allege those prior convictions we discussed with you, are those allegations in those particular paragraphs in each of these indictments true and correct as they are alleged? And are you pleading true and correct to those indictments, allegations voluntarily and because they are true?
Yes, sir.
Show you what's marked as State's Exhibit 1 in each case. Did you sign those documents?
I did, Your Honor.
Did you understand them, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each case
No objection.
without objection admitted. The state you were mentally competent to enter with guilty pleas, they are free and voluntarily made. You know what you've been charged with, the indictments and the read you've read them. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation by your attorneys. All true, so help you God in each case. State's Exhibit 1 is made a part of the record in all cases. Pre-sentence reports waived in these 2.
Yes, sir.
I'm going to follow these agreements and find you are indeed pleading guilty voluntarily, knowingly, intelligently to paragraphs 1, 2, 3, and 4 of the indictment. In each case, which constitute a state jail felony, punished as though it were a third-degree felony. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty, and there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt in each of these cases. I am following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That sentence of confinement is suspended and you were placed on regular probation for 10 years in each case. There will be terms and conditions of probation, which are normal and customary for these types of offenses. Among other things, you will also have to take a theft prevention class. There will be that is long overdue. Should have been 12 convictions ago that you took something like that, but I guess it's never too late to do the right thing. There is restitution, I believe, in one of these cases. Is it, which one?
It's in cause number 24 DCCR 1368, $798.
$798, and that goes to the complainant Bailey Monso.
That's correct, Judge.
There's no fine in each of them.
I don't typically do a fine when
I
they're.
understand, but there's no fine in each of
That's
them, right?
right, Judge. Good writer's credit.
Almost. I think that should do it. Thank you.
I was the first one was on the record. Revocation, that instance could be around the second to three. I say that because it's the length of the criminal issue.
Stand back.
I wanted to make sure I know I was. Because of this history.
Okay, what, go ahead.
Your Honor, I would request that the court admonish the defendant on the record that in the unfortunate event of revocations, it would be optional that the court to affirm these sentences consecutively.
Have you discussed that with him?
I just now I have, and I wanted to make.
Do you understand?
Yes, it is.
All right.
And I could do that in a bunch of caution because it's criminal history. Anticipating Mr. Ham's argument in the event of a revocation.
All right. So you've been put on notice.
Yes, sir.
Do you understand what has happened today, sir?
I do, Your Honor.
Now, looks like a couple of cases will be dismissed. Is it two of them?
Yes, sir.
I have just one, 490.
There should be two.
The case is hereby dismissed.
It's one says on 491, but he pled on it. So
That's true. He's got to send you the
but
right.
I think it just was an error. I think it was.
You're not good. The two that he pled on or 491 and 1368, and the other two should be dismissed.
Yeah, I just
So it needs to be
dismissed 1357.
That means 489 is the dismissal that needs to be served.
Okay.
Okay. I just signed 490. And so say we just need dismissal on 49.
Judge, when I get it from the prosecutor, I'll forward it to you. I don't have it.
Okay,
We're done.
we'll be done. Thank you.
Thank you.
Okay, I have Kenrell Abraham. Is that right, everybody? Kenrell Abraham?
That's right.
Who's on that?
That's Mr. West, and he's on the.
Where's John? Where is he?
I think he's in the battle, maybe sign up somebody else, but this was the case.
You ready on Abraham?
Yes, sure.
Come on up, then.
You're right, I think.
This is Mr. Abraham.
He's having, I'll go over it.
Mr. Abraham, please raise your left hand for me. Swear or affirm to tell the truth and prove nothing but the truth shall be found. And you got your right hand tight, right hand down. Like, one more time I did that. A little bit darker than that. Look, no. You can have. Established, you know what I'm saying?
What are you doing on this?
Okay, that's good. You go through.
All three? She's pleading on all.
Yes, for 5, so he's SEC.
Three cases are called 24 CR 206, 209, and 212. The state of Texas versus Kenrell Abraham, that's you?
Yes, sir.
Present with your attorney, Mr. West, and the state's attorney. Does the defendant waive formal readings of these indictments and these arraignments here? Can we proceed in summary?
Yes, we can, Your Honor.
We'll take them together?
Yes, I think all three up together.
All right. In summary, each of these similarly allege that on or about December 6th, 2023 in Jefferson County, Texas, you committed 3 aggravated robberies, first-degree felonies. Do you understand what you're charged with in these cases, sir?
Yes.
If convicted of a first-degree felony, as alleged in each of these cases, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Agreements have been reached where you would be pleading guilty and is this 5?
Yes, sir. You guys gotta give me.
I've written the 5. I remember it was in plan and making, but we'll leave
I guess
it.
I started using the Roman numeral also.
I can see with I's and V's what y'all would be up to and X's. You really make a mess. Each of these cases, you're pleading guilty and you would be sentenced to 5 years in prison to run concurrently. Is that right?
Yes, sir, that's correct.
Is that your understanding?
Yes.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead in each of these? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. Did you sign those documents voluntarily?
Yes.
Understand them, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you were mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, in each case, made a part of the record for all purposes. Pre-sentence reports away.
Yes, please.
I'm going to follow these agreements. If nothing further, in each of these cases, Mr. Abraham, I'm going to find you were pleading guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1. Admitted into these hearings to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. I am of these first degree felonies of aggravated robbery. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years in each case to run concurrently. Now, the judgments shall also affirmatively reflect that deadly weapons were used in the commission of each of these crimes. In 206, the deadly weapon was a pellet gun. In 209, the deadly weapon was a firearm. And finally, in 212, the deadly weapon was a firearm. Do you understand what has happened today?
Yes.
All right. Anything else?
Nothing, Commissioner.
Okay, that is that. Thank you.
During our website, Mr. We didn't successfully registrations. Again, conflict. We didn't hear. Should be on there. Never know these tablets. Get back out, man.
It speaks on handling.
Their feelings get hurt. It's not working. I know.
All right. Who is it, John?
It's Cordell Howard. It's just sex.
Where
We
is-
write down a plea right there.
Come on up.
We write down his plea, which we had to do the sex offender registration requirements. Filled it out.
All right, Mr. Howard, did you sign that? Is that your signature to that document? Okay. And I'm talking about cause number 22-39695. And here this states that you have a reportable conviction or adjudication which requires you to register in the sex offender registration program of sexual assault. And that you acknowledge you have been admonished or reviewed by your attorney with your requirements that failing to report conviction or adjudication and to comply with the chapter 62 of the Texas Code of Criminal Procedure, sex offender registration, failing to do that properly is a criminal offense that may result in prosecution. If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. Failing to do so can result in you being charged with a criminal offense. And do you understand your obligations here? And I believe this will be for life. Okay. Anything else? No, that is all on Mr.
Okay.
Okay, I have Julio Allende,
Yes.
finally. And I've got 4 cases. He's pleading to what?
Your Honor, he's gonna plead on the clause number that ends on 1485.
The other 3 to be dismissed.
Yes.
Okay. And we'll need Julio Allende.
Oh, here's our. Mr. Alende, please raise your right hand for me to swear or affirm have the truth, the whole truth, and nothing but the truth, so help you God. Okay, you can throw it over it. Okay, place it flat right there. Now one more time. Thank you. Place it right there. You can go see, step in front of judge.
But you, sir, is Julio Alejandro Allende.
Yes, sir.
Present with your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here, Mr. Kelly? Can we proceed in summary?
Yes, please, Judge.
In summary, this indictment alleges that on or about December 26th, 2022 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you're charged with?
Yes, sir.
It's a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty and then placed on deferred or unadjudicated probation, which can be up to 10 years in length. Restitution will be ordered in the amount of $3,700, I guess, to the complainant in this case,
Yes, sir.
as alleged in the indictment.
Yes, sir.
3 other cases will be dismissed.
Yes, Judge.
Is that your understanding?
Yes, sir.
If I follow this agreement in these cases, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in 1485, the second-degree felony, burglary of a habitation, guilty or not guilty? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 there. Did you sign that voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. This states, among other things, you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and adding lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. Correct? State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, please, Judge.
I'm going to follow this agreement. You find you were pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. You must follow terms and conditions of probation. These are normal and customary for this type of offense. You must pay restitution to the complainant, in this case, Richard Brown, in the amount of $3,700. Quicker you pay that off, the quicker you get rewarded. I can shorten probation term to 1/3, which is how much? What, 10? 3 1/3 years, if you do one. How long before you can pay this restitution back? How long before you can pay the restitution? That's what's important.
Like couple months.
The quicker you pay it off, the quicker you get rewarded. Are you able, that's $3,700. Are you able to do that within 6 months?
Yeah.
Sure.
Yeah.
All right, then that's what we're going to add as a condition of probation. If you are unable to, make sure you tell your probation officer so that they know. Because sometimes people get in a financial bind, but paying the restitution back fixes a problem. The quicker, the better it's fixed. Okay, anything else?
Not much.
That is all. I think 3 cases, right? And get dismissed. Yeah.
Yes.
This is what it takes just to dismiss them. There it is. It's just screen. And maybe it's, oh, that's out again. And it's blank screen. And it's coming back, maybe. Ah, there it is again. For each case. Each one. Steps along. Okay, done, Tom.
Thank you.
Thank you.
Thank you.
Sure. Here. Were there any other pleas off this? No? Where's Langston Adams?
Judge, I believe he's trying to work on one plea that he's.
Yeah, but LaShonda Elam. What are we doing on that one? That it looks like it is, who is that? That's Sarah's.
Which one you're on? Yeah, that's fine.
I'm in. LaShonda Elam, what are we doing on that one?
Heard from the defense on others
Okay.
here.
Elijah Gill, that's another Langston Adams case, and that's Mr. Eckert. What are we gonna do? Do you know?
Judge, that's one that I'm gonna ask for a little bit more time before making an offer on.
Okay, what does he want? Is it?
Mr. Adams said he didn't have a problem with that.
So we're gonna reset Elijah Gill.
Yes, sir.
How far?
23 CR 377, how long?
Days.
Then I have Desmond Harper
I think that's who he's talking to right now, Judge.
and Glover Jones. That's also Langston Adams.
Unknown, Your Honor.
Unknown. Cortland Woods.
That's signed up as a plea.
That's a plea, Judge.
Really? I don't see it.
I haven't signed.
Who's
it yet.
Cortland? Are
It's
you
just-
Cortland? And your attorney is Mr. Adams? Can we get Langston Adams out real quick? Comment, thank you.
And Your Honor, on Mr. Harper, that's the one, he was sentenced to 20 years TDC on.
No, it's
Oh,
not.
it doesn't, oh, that's the son, okay, fine, excuse me, Your Honor. I was thinking that was the other Desmond Harper.
That's right.
Yeah, Dan, anything you'd like to add on that?
No, Your
Last
Honor.
one, that last remark? Yeah, there. The DA's office conspiracy to confuse the court in any way possible. I have Darren White with Tom Burbank. Where's
You already did a plea, Judge.
Yeah. Thank you. I thought that was for me. Okay, on DeLister Brister.
I haven't seen Mr. Doyle.
He may not be here. I think he may be ill. DeLester Brister, where's Mr. Brister?
He's in jail, Judge, and Mr.
Is that a hand?
No.
No? Okay.
Yeah, Mr. Brewster.
Yeah, don't raise hands. You get called on.
Mr. Brewster is in custody and,
All right, and so DeLester Brister, that almost rhymes. It's going to have to be reset, correct? 2 weeks, 2 weeks. Thank you. Mr. Grove, what are you doing on Jador Ernest? Jador Ernest.
Judge, I'd like to have it reset. I don't even have it scheduled on that, Your Honor. I haven't ordered it and I would receive it for sure the next day.
you don't have any of these files, Judge.
Probably one I'm not finding them. Do you have it? And then I have Clarence.
These are.
Okay, on Jador Ernest 24 CR 1309. What did you say on that one?
I'm like just 3 weeks from
Okay, where's Mr. Ernest? In custody or on bond?
Custody.
Custody, I believe.
Yeah. Okay, how much time did you say then?
3 or 4 weeks.
How about 4 weeks? Is that good?
Yes, sir.
Okay, 24 CR 1309, Jador Ernest, reset 4 weeks at request of defense. Clarence Small. 22 39889. Clarence Small indicted 3 years ago.
He was indicted 3 years ago.
Where's he been? Is he in custody right now?
He's been in TDC for a number of years. Studied to register as a sex offender and trying to find out why he has not registered, but he's been in custody. Judge.
I know, but he's here right now, right?
Yes,
he
sir.
here?
He is in Judicial County.
No, is Clarence Small here?
I saw him last night, Judge. He is.
He should be here. We should have bought him.
Harper.
That's a very
Your name, sir? Okay, well, welcome.
Yes.
Have you ever met Mr. Grove, your attorney?
Yes, sir.
Okay. You know you're charged with the third-degree felony of failing to comply with sex offender registration. If convicted, that carries with it no less than 2 nor more than 10 years confinement in prison. Also, a fine up to $10,000 can be assessed. Do you understand
Yes, sir.
the punishment range? All right, what are we doing today? That's an announcement, I believe.
Judge, I'm trying to find the discovery on that matter. He's been registering since 1991, but he's been in custody almost the entire time and trying to locate the records on him.
How long is that going to take?
I would say 4 weeks. We should be able to get it from the Beaumont Police Department, Judge, but
okay.
I don't have it yet.
When were you released from prison? Have you been released from prison or?
Yes, sir. I just got back on a technical violation. That's why.
How long were you out? When were you released from prison?
2019. And I worked at Jordan Marina for 8 months, and then I surrendered on the halfway house on October the 26th or the 29th. And I stayed.
Of what year?
2019.
Okay, and you've
So I
been.
was out 8 months working at Jordan Marina. That's why I didn't even, I have short.
When were you taken back into custody?
March the 17th of 22.
Okay, and you've been in custody ever since then?
Yes, sir. I went back to TGC and did, from March of 22 to, May the 14th, I came over here to Jefferson County Jail.
Just recently?
Yes, sir.
Yes, sir. He's been here less than a month.
How much time does he have? Credit, did he die? He was indicted on May 18, 2023.
Yes, sir. And the indictment, I could, looking at his prior conviction, because he had 2 prior convictions before that, which made him habitual. That's why he got 25 years on a sexual assault on a plea bargain. So I could make this habitual, but I made him an offer of 7 years. So.
Judge, I have not seen a document, and that's the problem. I think we might be able to do something. I'm just.
Oh, yeah, right now, today, what are you asking for?
Some more time.
How much time?
4 weeks.
You got it. Yeah, we said 4 weeks from now. So. Reagan Minaldi, Clyde Freeman.
Something, sir. Say something.
Go ahead. Good luck, because I don't know what it's gonna. I don't know what you're gonna say, but it's taken down. So
I mean, since I got to 25, going up under the 2 40-year sentences, I haven't never had to sign but one time because I've been in and out of the going back on a technical violation. So I never forgot all about signing. I have short-time memory loss ever since I've been in special education in the 5th grade, from the 5th grade all the way through high school. Never had a driver's license or nothing for the technical knowledge. That's the only reason why I didn't sign, is because I didn't even know. But I was every day when I was at Stano, I was up mowing yards and I didn't run nowhere. I stayed right there in my. That was the last place that I signed for, what do you call it?
I'll talk to him about it. Yeah, I mean, I'm not going to say, okay, you can go home. No, that's not the way it works.
Just let
Yeah.
the court know.
Well, yes, slippage of the mind is everybody forgets things, but you have consequences if you forget this. Now, if you're incompetent or insane, that's another situation altogether. But that's not for me to decide. That's for him and you to work out.
Yes, sir.
All right. I'm gonna reset it 4 weeks. Clyde?
Yes, Judge. Today, we are set for sentencing on his case. He has already pled. However, it's come to my attention that he's not properly registered currently. To get on him, I can ensure that he's registered properly by then, and then we can come back for good.
All right, reset 2 weeks.
Thank you very much. Yes.
Karen Johnson.
She's gonna be set for a hearing, Judge. On her MTR case. If we could use 4 weeks on that. There was a first amended MTRP file for her, still waiting on the information relating to the new office. It's alleged.
Do you have that, Karen Johnson? Who's on this one for state? Okay, so Ms. Johnson was placed on 6 years deferred or unadjudicated probation in 23. And then looks like an indictment rolls around in March of 24 for the third-degree felony of evading arrest or detention with a motor vehicle. Then a motion to revoke probation had been filed, 2 months earlier, looks like, in January of 24, alleging the defendant committed terroristic threat, failed to report, failed to provide verification and perform community service hours, and in arrears on fees. So in all of this, it looks like the way we're going to proceed is we will have the motion to revoke probation hearing. When can we be ready on that? All right. All right. We said 4 weeks.
Thank you, Judge.
That's on Johnson, James Mendoza.
He is requesting to set the trial, Judge.
James Mendoza. Do you have his file, please?
Oh, I'm sorry, do you want?
Mendoza. Sorry.
Oh, it's okay. Yeah. Mendoza. Got a reason on him. Well, we did. Yeah, that was, August 5th. Yeah, and I know that I'm gonna. Yeah, yes.
Okay, I need Mr. Mendoza, please. Thank you.
In an effort to try to move this case, Judge, even though he's habitual, the state has made an offer of 12 years.
Yeah, he sounds like he's not interested in that.
Well, yes, I understand. Your Honor, I'm just giving you information before you get started.
Nothing ever happens good at 4:40 in the morning. That's what I was always told. 24 CR 1769 is now called James Philip Mendoza. You are James Philip Mendoza? Yes. And you are here with your attorney, Ms. Minaldi, and the state's attorney. You are charged with, in this 24 CR 1769, an indictment handed up August of last year. And it alleges that on or about June 23rd of 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with? Yes, the guy. Okay. But it doesn't end there. The indictment goes on to allege that you have a DWI third-degree felony conviction in 2012 out of Lubbock County, Texas. After that became final, according to paragraph 3 of the indictment, you committed the offense of illegal possession of a controlled substance, a first-degree felony, and you were convicted there in the 364th District Court of Lubbock County, Texas in 2017 of that offense. So if all of this was true, and you were convicted of this evading arrest, and those prior convictions were proven true as they are alleged, you are looking at being an habitual felon, which means you face, if convicted, no less than 25 years up to 99 years imprisonment or life imprisonment. Do you understand what you're facing on this indictment?
Yes.
All right. Well, what are we doing?
Judge, he's requesting his case be set for trial.
All right.
Mr. Ham has relayed an offer of 12 years to abandon the habitual enhancement, but to proceed on an enhancement that would increase his range of punishment to a second-degree felony. So the offer was 12. He's choosing to reject that offer. Right.
Okay, that's what he can do. It's his right.
And he wants to set his case for trial.
All right. It will be then set for trial, and Miss Finale can certainly handle this. She's a very competent lady. It'd probably go quicker to trial if the public defender, if you agree to release her, one of the other rotation lawyers or ready, willing, and able to try cases. Is that what you?
Yes.
Right to do that? Okay. And on this case, there is no deal. We're going to trial on this. I don't accept a deal on it. So let's move forward and get this to trial as soon as we can. Thank you. And you are released.
Thank you, Judge.
Next lawyer will be appointed. Rhonda Roberts is next. Note that, no deal. Note it, no deal. So I don't forget. Thank you. You have a bunch of cases here, Rhonda
Yes,
Roberts.
Judge. I have not had time to thoroughly go over what she's.
How much time do you need?
I'll get 4 weeks on her, Judge, for an NTRP announcement. I'm hopeful that we can use it.
Good morning, Lee. How are you? You can come out. Court does call the case of People's State of Michigan versus Jerome Burns.
Good morning, Your Honor. Marie Townhouse. And good morning, Your Honor. Assistant Public Defender Shannon Carey Kimberly on behalf of Mr. Jerome Burns. From Jerome
Burns. All right. All right. Date and time set for preliminary examination. Are we ready to proceed?
People are ready, Your Honor. Defense is ready.
Okay. You may call your first witness.
Oh, I'm sorry, Your Honor. Before we start, I was going to approach the court about two things. One, just generally sequestration order. If there's anybody in here that may be a witness in this case, I'd ask them to leave the courtroom. We've had our, I'm sorry, family, just 1 second. There are two things I'm sorry about that. We've asked our witnesses to leave. The OIC is still present. And the other, the people on our side are not going to be testifying.
Okay. So all the witnesses have been sequestered on the people's side.
Your Honor, I do not plan to call any witnesses today.
All right.
And they're not going to be called later on in the case.
Well, I don't know if one could commit to that. I mean, I understand what may be the people's concern, but if they're going to be called later, they certainly could read a transcript. So, but the question would be their testimony today. Counsel approach brief. Go ahead.
One other matter, Your Honor, I've spoken to defense counsel both last time as well as today about defendant's cell phone. He had claimed there was some evidence on there that may be potentially exculpatory. I spoke to counsel. I think we've spoken to Your Honor about how we would approach that if he would like to retrieve that for him. My understanding is, I'm not sure we have a clear answer, but my understanding is that that is not something that he
would want for today's purposes. And Your Honor, I think one of our primary concerns was the cell phone in question was in my client's possession when he was arrested. Our understanding is that, U of M PD later came to the jail to take the cell phone. So I'm not sure, my client did not have any conversations with anyone other than counsel about information that he would like to retrieve off of his phone. I'm sorry, I think he may have spoken to his father about information that he wanted to retrieve off of his phone. And when his father went to the jail to go and retrieve the phone, he was told that he had just missed it and that the police had just picked it up. So I'm not really sure where the information about exculpatory evidence came from. I don't have anything in my notes. I don't know if it was something that came from my office. However, it was information that our client wanted us to investigate ourselves. We're not inclined to advise him to give passwords or access to his phone to the people at this time. There may be a motion. I think I informed Sister Counsel that there may be a motion that we may file just to get the phone back, because our position is that if the phone is not evidence in this particular matter, then the people have, or the police have, no real reason to hold on to the phone if it's not being used to investigate. If there's information that the police would like to get off the phone, I'm sure that there's a search warrant of some sort that they may be able to get. Other than that, they're really just holding on to the phone, and unless we give them access to the phone, they're not willing to give it back to us.
Go ahead.
Yeah, Your Honor, just in response to that, that's not quite the situation. So, Your Honor, specifically, defendant claims there's a video on his phone of the victim consenting, which is a big deal if that is something that's truly on there. With that, our anticipation was that he would want us to retrieve that or somehow get that evidence. And we are willing to be creative in how to go about getting that limited evidence. However, so far, and as we stand here today, we have not been given permission. Now, we could absolutely go through a search warrant, and that's what we're going to do since we're not being given consent. I think there is good reason to believe there's information on there related to this case. But we wanted to present that opportunity anytime something is even close to being potentially exculpatory, whether or not I believe defendant that he has that video. His statement alone that there might be is concerning to me, and I don't want to be in a situation where it's later claimed, and I'm not saying by counsel, just later down in this case, where it's claimed that there was exculpatory information that we somehow didn't share or were in possession of. So, of course, the best way to go about is consent. I completely understand his perspective if he doesn't want to give that consent. So we can just go about it through the traditional search warrant ways.
Anything else?
Nothing else, Your Honor.
Well, correct me if I'm wrong, counsel. I think we had an in-chambers conference about this issue. And my understanding was there was going to be understanding what may be the perils of that and the fact that the people could get a search warrant, that there was going to be a decision made by the defendant prior to preliminary examination about whether or not to try to retrieve that information. Exculpatory. My understanding, Ms. Akinwumi, is that he does not wish that to occur. Is that correct? You may want to, that mic. Secondly, before you say anything, you want additional time to try to talk to your client about that.
If I could, Judge.
This will do is I was saying in recess, you let us know when you're ready.
I sure will.
Take back.
All rise.
Thank you.
Okay, see.
We're back on the record in the case of the People versus Burns. There's been certainly a break. Counsel and I have had a extensive bench conference regarding the issue that was raised. Secondly, it's the court's understanding, and feel free to correct me if I'm wrong, and I will ask your client to acknowledge this, that there might be some, I guess, different interpretation of what is contained on the phone. Your client may believe that it might be exculpatory for him. However, my understanding is he wishes to proceed today on this understanding that that won't be released. That fashion, and he's not consenting to release.
That is my understanding, Your Honor. I have had an opportunity to speak with my client. I've explained to him where we are and what the people's request is. He states that although he does believe that that information is on his phone, he is not inclined to give consent or permission to the people to access his phone to take that information.
All right. And Mr. Burns, is that a correct statement, sir?
Yes, sir.
All right. And you understand that as far as this proceeding, that we will be proceeding without that information. You understand that, sir?
Yes, sir.
All right, very good.
Thank you, Honor. Marie Tanner for the people. People call Madison Burns. Please stand.
They're gonna have to back up as well. Thank you, folks. All right, ma'am, if you could please come forward to be sworn.
Please take a seat, raise your right hand. Solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. Yeah, see, please spell your first and last name for the record, please.
Burns, M-A-D-I-S-Y-U-R-N-S.
All right, may inquire.
Thank you, Your Honor. Hi, Madison. Thank you for your patience. I know it took a bit this morning. A few things I want to talk to you about before I start asking you questions. First one is, this is Judge Simpson. I wanted you to kind of know what we're all doing here. We're going to start with, I'm going to ask you some questions. After I'm done asking you questions, if defense counsel has questions, she'll ask you some questions, okay? If it's necessary, I'll come back up and ask some more questions, but that may or may not be necessary, okay? When you're answering questions, if you could say yes or no, as opposed to that'd be really helpful. Okay.
She goes, All right. All right. Go ahead.
Okay, thank you. And you're a little soft-spoken, I am too, so we need to be really good about getting close to the microphone when we're speaking, okay? If I ask you a question that you don't understand, it makes no sense to you, please let me know that you don't understand, ask me to ask it differently. That's okay. All right.
If you can't hear me, please tell me to repeat myself. Okay. Same thing with defense counsel. It's perfectly fine to say that you don't understand or you can't hear or whatever the situation is. Okay. If you need a break, with the court's permission, that's okay. You can raise your hand, you can ask for a break, whatever you need. Okay. All right. Madison, do you know someone by the name of Jerome Burns? Okay, who's that person to you? And
Let me stop you for a second. Madison, you're gonna have to do me a favor, okay? Yeah, you're gonna have to speak louder. The thing about these microphones is they don't amplify, okay? They will pick up everything that is said, but not everybody can hear it, okay? And so when you're looking at me, I'm an old guy, so I need a voice, okay? All right, thank you.
thank you, Your Honor. Okay, and you said Mr. Burns is your husband. Do you have a child or children in common? Okay, and tell me about that. How many children?
Just one. One is 5.
5. And what's his name?
Benjamin.
Benjamin. Okay, thank you. Do you see Mr. Burns in the courtroom today? Could you describe something he's wearing? Okay. And which side of me is he seated on? Okay, sometimes that gets confusing. Your Honor, may the record reflect that the witnesses identified the defendant.
Without objection, record shall so reflect.
Thank you. So you said that your son's 5 years old. And how long have you been married to Mr. Burns?
2 to 3 years.
Okay. And were you in a relationship prior to that? Okay. I want to ask you a little bit about that relationship with Mr. Burns, your relationship with him, and then the marriage. During your marriage, could you tell me a little bit about kind of your financial situation? Okay. And where was that coming from? Why did you feel like you weren't allowed to have your own bank account? Okay. And who told you you couldn't have your own bank account? And when you say he, I'm sorry, this is really annoying, but who are you talking about? Jerome Burns. Okay. Thank you. And did he tell you why you couldn't have your own bank account? Okay. No problem. So you had a joint account with him? Did you work during the marriage? Okay. So how did you and Mr. Burns have income? Okay. At some point, did you come into some money during the marriage? And what happened with that money?
Most of it I'm sorry, what'd you say, young lady?
Did he allow you to open an account separate to put that money into? Tell me a little bit about, did he have a vehicle during the marriage?
Yes.
Okay. And who drove that vehicle? Did you drive that vehicle? Why not? And who stopped you from going and you were by yourself? if anyone?
Judge, I'd like to object to this entire line of question, and I think that it's relevant to the issue at hand of why we're here today, and the event that occurred on May the 7th of this year.
May I respond, Your Honor?
You may.
Thank you. Your Honor, it's extremely relevant to what's going on. We're here to establish coercion. That is what this has been charged under. Notably, as the court's aware, I'm sure counsel is aware as well, coercive control is the underlying concern we have in these domestic violence type of situations, which is very much is. As the testimony develops, we'll hear more about that. These are all parts that go into showing that coercion.
Anything else, Ms. Ecken?
No, Your Honor.
Objections overruled. You may
Thank you.
proceed.
Thank you. So I'm sorry, Madison, who, if anyone, indicated to you that you were not allowed to go anywhere by yourself in the car? Were you, if you know, were you listed on the insurance for the car? Did you want to be taken off the insurance? Did you ask to be taken off? In whose name was the car? Jerome Burns. Thank you. I want to ask you a little bit about where you lived with Mr. Burns. We don't need to go all the way back, but let's just look at like 2024, 2025. Where were you living with Mr. Burns? And were you on the lease for that apartment? Who was on the lease for that apartment? Did you ever have a cell phone? Do you own a cell phone? And did you was that cell phone always in your possession, or would someone else have that cell phone at times? Okay. Can you tell the court more about hourly check-ins? What does that mean?
Every hour.
And who asked you to? You said he. Who asked you to do these things? Okay. And what would happen if you missed one or didn't obey that request?
So, Madison, can you describe this check-in? Was that like on a daily basis? And so this hourly check-in, you would have to call him or text him every hour. And so in the text or in the call, what were you supposed to inform him of? Okay, so I'm just trying to get, it's okay. So every hour you would have to in some way communicate to him what you were doing. How long did that last? A month or two? Okay, just backing up to something else so that I have a full picture of this. Was that during the period in time at which you had to put the phone on the dresser and weren't allowed to look at it? that you had to shut the phones off. Do you know why that was or why you were told that, or did he tell you? You had to shut your phone off. Go ahead, Ms. Tanner.
Thank you, Your Honor. I'm sorry, Manson, you said that if you didn't obey his directive regarding the texting or calling him, I believe your testimony was that he would yell at you. Is that correct? Okay. Can you please tell the court, if you remember, what kinds of things he would yell about, or what would he explain what that would look like? And how would that make you feel? And was Benjamin, were you home with Benjamin often? Okay. Okay. And when Mr. Burns would ask you what you were doing that you didn't check in with him on an hourly basis, what would be your reaction to that? What would you do? And would that satisfy him and calm him down? And when it didn't, what would that look like? Okay. What was his tone and demeanor as he would accuse you of those things? Okay. And how did that make you feel? And I know I'm asking you to kind of think back, so if you don't remember, it's okay. What were you scared that Mr. Burns might do? Okay. I want to talk about Benjamin a little bit. Does Benjamin, because you mentioned the hospital, and that's what we're here to ultimately talk about. Does Benjamin have a medical condition or conditions?
Yeah, he has a muscle condition. Very rare. Epilepsy.
And you said that Mr. Burns threatened to take Benjamin away. How often did he threaten to do that? What would lead to him threatening to take Benjamin away? What would kind of happen before that threat came? Okay. So he would accuse you of talking to someone, and then at some point during those accusations and the yelling, is that?
What will that ever happen?
Did you believe him that he might take Benjamin away? What concerns would that cause you? I know it seems like a silly question, but what concerns would that cause you, given Benjamin's condition, if Mr. Burns took him away from you? So Benjamin's kind of medical procedures, talking to the doctors, medications potentially, was that on you, him, or was it a shared responsibility? And during this time when you took care of Benjamin and kind of coordinated his care, was that still going on when Mr. Burns would ask you to do hourly check-ins? Madison, do you have any family locally close by?
Not close. And I have left this my brother and my dad's mom. They live in California.
Okay. Is your father still with us?
January of this year.
January of this year? So when you and Mr. Burns were in the hospital for Benjamin in May for this incident, your father had passed away a few months prior to that.
Celebration of life. He had an attitude that he wasn't gonna be taking me because my parents told him specifically over the phone. Objection, Your Honor, hearsay.
Okay, hold on.
Sorry, you have to wait a second. Your Honor, it's not offered for the truth of the matter right now. This is to establish her mindset.
I don't think that that establishes any mindset, Judge. If it's something that she's claiming my client was upset about that someone told him, it has nothing to do with her mindset at all.
Well, it would if he then communicates that in some way to her.
I don't think that's what she's saying. She's just telling us that he was upset because.
I can ask it directly, Your Honor. if
Yeah.
it would help.
Well, okay,
That's
then
fine.
I'll sustain that at this point, but go ahead.
Thank you. Did Mr. Burns do anything or say anything to you that that he was to indicate he was upset about him not being the one to take you?
He told me that he wanted to be the one to take me and at least sit in the parking lot if he wasn't allowed in there because he wanted to be there for me. My grandma had told them that.
Objection.
He wasn't allowed there and he wasn't allowed in the parking lot.
Again, Your Honor, it's not for the truth of the matter, whether or not
I'll overrule it. I'll accept it. I mean,
it's okay. We can move on.
in accepting the answer, I'm only taking that answer to that last part as it gives context to what she's saying had occurred between her and the defendant. So go ahead.
Thank you. And how often would you be able to see your family? The family you had left?
Maybe once a year or 2 years.
Okay. Did Mr. Burns have any, or did he express any opinions about you seeing your family?
That they had to come see me. That have to run back and forth.
To have you go see them? So I want to talk a little bit about, I might ask some more questions later, but I want to talk a little bit more about the hospital, the reason we're here today. So on May 5th, were you at Mott's Children's Hospital with Benjamin? I'm sorry, May 5th of this year, 2025. And what were you there for?
Someone's going to be getting a MG being due for them.
And was he admitted for that procedure? Admitted to the hospital, like you had to stay there? And at that time, were you living with Mr. Burns? Okay. When did you stop living with Mr. Burns and his parents? Okay. And what led to you not living there anymore? And when you say he, do you mean Mr. Burns? And you said it was your only chance to get out. Was that because Mr. Burns wasn't home? What in your mind would happen if you try to leave when he was at home? So on April 4th, he wasn't home and you decided to leave. Can you tell the court why you decided to leave? What was it you couldn't take any more medicine? It's okay. You need a break?
Madison, you need a break? If you want to take a break, I could use one. Okay. So court standing brief.
Thank you, Your Honor.
I heard it. Yes, please, I can be a much more pleasant person. Okay, good. May 29. We can then bring the defendant back in. We're back in the case of the People State of Michigan versus Jerome Burns. Got it. All right, the defendant is present. You may proceed, Ms. Tan.
Thank you, Your Honor. Listen, before we took a break, I asked you, you had made a comment about how you couldn't take it. That's why you left in April. And I asked you what you couldn't take anymore. You started telling us about that. Could you please tell the court? And for how long was that going on? And how long were you together, counting the dating and the marriage? Okay. Thank you. I don't want to go into too many details, but I do want to ask you a little bit about what the emotional abuse looked like or sounded like. And did you? Were you?
Madison, when did that happen? So I'm sorry. I just trying to understand. So you had one pair of shoes?
But they were old. Bought me new shoes, which were slip-on Skechers.
And just because I'm trying to get it, those were the only shoes you had at the time? Oh, well, you're right. You're actually answering my question, but I want to. Those are the only shoes that you were allowed to wear?
Yes.
So you had one pair of shoes that you could wear? Thank you. Go ahead.
Thank you. Madison, you said you hid the other shoes in the closet. Why did you hide them? And what was your concern, if any, would happen if Mr. Burns knew that you intended on keeping the other shoes? You said there were things he wouldn't let you. We've talked about some of them, like going places by yourself, driving cars, the phone thing. Were there other things? Did you feel like you could hang up on him on the phone and continue your walk? And what would happen if he came rushing home in your mind? Okay. And what would, I'm sorry, I didn't hear that last part. I apologize.
So, I'm sorry. I just want to be clear. When he FaceTimed you that you had to come back, was he at home? He was at.
And you said that if you didn't obey essentially and go home and you had hung up on him and continued your walk, that he'd lash out, and then you were saying something else.
Several times.
And is that why you did as he told you to?
That a yes.
Oh, sorry.
Sorry.
Okay, and Madison, you had mentioned some sexual assaults. I don't want to get into details of those because they're not charged in our jurisdiction. But can you just tell us, generally speaking, when those occurred? So you get body aches. And would this be during the time he would assault you sexually? Okay, in general. And you said you would ask him to stop. And when you say you asked him to stop, you mean you would ask him?
Everyone is Judge, because this is, again, we're talking about situations that didn't happen in this jurisdiction. I understand the people's attempt to elicit maybe, state of mind or reasonable fear, but I don't.
I'll sustain the objection.
Yeah, that's okay. We can move on. I was asking more for the timeline. I apologize. So around what, how many years ago, months ago? I'm sorry? Okay, thank you. Okay, so going back to May 5th of 2025, you're at Moss Children's Hospital with Benjamin. He's getting treatment. At some point, did Mr. Burns come to the hospital? Okay. Did he give you a reason as to why he didn't want her to come back? Were there arrangements put in place of how and when you were going to be with Benjamin in his room and when Mr. Burns was going to be in the room? Okay. So were you in the room together with Benjamin? Okay. Before, we're going to get to questions about the assault, but before the assault happened, oh, let me ask this. I'm sorry. So, how long, if you remember, how long had you been in the hospital with Benjamin when the assault happened? Total? Okay. And did the assault happen right when you got there or a couple of days or a few days later? Okay. Leading up to the assault, did Mr. Burns engage in behavior that concerned you? Okay, can you tell the court about that, please?
Told me that he was feeling suicidal. Told me that he took half of a bottle of Tylenol.
And was that his first time talking about suicide? Okay. Can you tell the court if that's happened previously? And so in the hospital, when he was threatening suicide, did you believe that he might actually kill himself? Do you need a break? Are you doing okay? Okay, all right.
You said you're fine? Okay, just listen. It's okay. If you need a break, it's probably good for me to walk so I can get up at any point in time, okay? So you just tell me, right? Go ahead, Mr.
Thank you, Your Honor. Was the threats of suicide before or after the assault? And since Benjamin was there several nights, did Mr. Burns and you stay at the hospital overnight? Okay. Where were you sleeping?
I was on the chair.
Together on the mattress? Did you want to sleep on the mattress with him? Did you end up sleeping on the mattress with him? Did you feel like you could tell him that you didn't want to sleep on the mattress? And when you say attitude, could you describe to the court what you mean by that?
Just kind of. All her main comments.
And what were his comments? Okay, that's okay. Thank you. Okay. I want to talk a little bit about what more immediately led to the assault, okay? At any point while you were in the hospital room with Benjamin, did Mr. Burns touch you in a way that was against your will? Okay. Can you tell the court how that started, please?
Got like touching my leg and like down that area, and of course just hand the leg, he just had it.
Okay. And you said leg and down in that area. I know it's hard, but I need you to tell me what specifically, where on your body did he touch? Okay. Again, I know it's really hard. I need you to be very specific about where he touched you. Did he touch your genital area? Okay. What part of his body did he use? We're talking about initially to touch your genital area. Okay. Did his hand or his fingers at that point ever enter your vagina? Okay. Okay. Did you want him to touch you in your genital area? And you said you were pushing his hand away. And what happened after you pushed his hand away? Was he saying anything? What happened after he was touching your leg and your inner thighs, your vaginal area? What happened next? Okay. At some point, did he ask you to do anything with him? Okay, can you tell the court about that, please? Did you want to have sex with him? Did he stop asking? Did he ask one time? Okay. Can you tell the court a little bit more about that interaction, how it went? So he was asking you for sex more than one time. Was it more than 2 times? Okay. And did you have a response to that? Okay, it's okay. At some point during his asking you to have sex, did you change your mind and decide you wanted to have sex with him? Okay. Did you end up having sex? Did it occur again that he asked you to have sex? Okay. Okay. I want you to, as best you can, describe a little bit to the court how come you gave in. You were worried he might take your son or kill himself. Okay. And we've already talked about his threats in the past to do so. Sorry, just one moment, Your Honor.
Yes.
And did Mr. Burns, and I apologize again, I know this is difficult to talk about. Did Mr. Burns end up penetrating you? Okay. What part of his body did he use to penetrate you? Okay. I need you to please say the word. I know it's hard, and it's okay to say, I know we're in court, but with the court's permission. Okay. And when he used his penis to penetrate you, what part of your body did he penetrate? Okay. And did his penis go into your vagina past what we would call like the lifts of the vagina, the outer parts of the vagina? Okay. And is that something you wanted him to do? Was it against your will? Did Mr. Burns use any other part of his body to touch or penetrate any part of your body? We can go with touch first. Did he use any other part of his body to touch your body? Okay. Did he use any other part of his body to penetrate your body? Thank you. And we've been talking about Mott's. As far as you know, Mott's Children's Hospital, is that in the state of Michigan and Washtenaw County? Thank you. After kind of the sexual penetration and what you've described to the court, do you remember if Mr. Burns said anything to you? Would it refresh your recollection if I showed you a statement you made to police shortly thereafter? Okay. Your Honor, if I may approach before I do so, I'm showing defense counsel page 4 out of 6 of the original police report. It has been shared in discovery.
Yes, you may.
So how it's gonna work is you're just gonna read through this part. You're not gonna read it to us, just to yourself, okay? When you're done reading it, just look up. When you're done.
Okay, thank you. Your Honor, may I retrieve it?
Yeah.
Madison, did that help refresh your recollection? Okay. Could you please tell the court if Mr. Burns made any statements after he penetrated you? Thank you. I do have a couple of questions that I missed. I want to go back to. You said you moved out of his parents' residence on April 4th. Where did you go? And what was that? Was that shelter specific, or what was it a shelter for? And when you left in April, did you, again, I don't want to get into the details, but did you make complaints with other police departments reporting the previous assaults? Okay, thank you. Thank you. Nothing further at this point.
Cross-examination. Madison, are you good? Okay, all right. Cross-examination.
Thank you.
Hi, Madison. My name is Chinaza. I'm with the Public Defender's Office. I'm representing Jerome. So I have a few questions for you, okay? All right. So you indicated just now that you and Jerome had been married for about 3 years, you said? Okay. When's your anniversary? Okay. 23? Okay. And you stated that your son went into the hospital on May the 5th. Is that correct? Okay. So when Jerome came to the hospital, how did he know you were at the hospital or that your son was going in for this procedure?
My church.
Okay, so, but you knew he was coming to the hospital, right? Okay, and you guys, you didn't go to the hospital together? Okay. And so if that was May the 5th, that means 2 days later was gonna be your anniversary of your wedding, is that right? Okay, and Jerome bought you a gift. Did he bring a gift to the hospital for your anniversary? You don't remember if he brought you an anniversary gift or any kind of gift to the hospital? Okay. You don't remember accepting a gift and telling him how much you loved the gift that he had bought for you? Okay. So when you all were at the hospital together, and you were both in the room visiting your son, is that right? And both of you stayed there for that entire week with your son, right? And when you were there, you guys, you played games together? Okay. You and Jerome talked a little bit, I assume? You're in the room together? Okay. I want to go back just a little bit. You indicated that your son had to get an NG feeding tube, right? That was the reason for the admission. What was the reason for that? Why did he need a feeding tube? He didn't have one prior to that, right? Okay.
Calories throughout the day are just food.
Okay.
A few days ahead of eat just as normal every day what you eat, just to see how many calories he was getting, so they could adjust for how much he would need to once they.
Sure. And that's something that they were doing at the hospital. Okay. No, I mean the monitoring the caloric intake at the hospital. Okay. But isn't it true that part of the arguments or issues with you and Jerome is feeding of the baby?
I'm gonna check, Your Honor. I'm not sure how this is relevant to whether or not the assault happened.
Well, Your Honor, I think that it's gonna go into some of the other allegations about the telephone and the excessive oversight that she alleged that my client had over her. We have a reason, or my client has provided me with some information as to what may have led to some of those things or some of those discussions.
Your Honor, I'm concerned not only that it's not relevant, because it's quite frankly, it's not. I'm also concerned that this is all going towards, defendant has multiple times threatened, talked about taking the child away by whether legal means or unlegal means, but we certainly had discussions about family court. This seems like an attempt to make this victim look like a bad mom, and it's not only not relevant, but it's highly inappropriate for this setting.
I mean, that's by no means what I'm trying to do. I'm just
And I'm
trying
not doing that on counsel. I believe that's defendant's intent.
So what would I do with what you're attempting to try to? Tell you what, I'll be able to sort it out. I'm gonna overrule the objection. I'm gonna give you a little bit of leeway.
Understand. Okay.
Thank you.
Thank you, Your Honor. So Madison, my question was just basically, I guess the bottom line is this issue with caloric intake, it was sparked by weight loss of the child, right? Okay. You know how much weight he lost? Okay. Now, do you recall some of the arguments between or some of the issues that, well, let me just ask it like this. You made some statements stating that my client would force you to put your phone on a dresser or a table of some sort, correct? Okay, and isn't the reason that he did that because he complained you were on your phone too much? Okay. He never complained to you about not feeding the child in the manner in which he was supposed to be fed? Okay. What about the allegations or issues that you guys had in regards to infidelity?
I'm gonna object, Your Honor, that to me, that's not an evidence. So unless there's.
Well, except that it's his accusation that that Madison actually testified to peripherally, but so I'll overrule the objection. Go ahead.
Thank you, Your Honor. You stated earlier that he would always accuse you of cheating on him, right? Or talking to other guys. I think that was what you said. And isn't it true that he has confronted you about talking with other guys and cheating on him? Okay. And isn't it true that you had multiple telephones, cellular phones? Okay, you had 2 cell phones. Okay, and you talked about you having to do these check-ins and having to keep your phone on the dresser, but my client goes to work, right? He would leave the home to go to work. Okay, and you stated that you lived with his parents at their home, and they also go to work. Is that correct? Okay, and you also testified today that your son goes to school. Okay, so at times you'd be at home by yourself or my client wasn't always with you in the house. Is that right? Okay. You also talked a little bit about him not allowing you to see your family who lived in Livonia, but he never told you you couldn't go to their house, right? Okay, but your testimony today was that he said he wouldn't take you there because he didn't have the time or the money to drive you there. Okay. So what would happen if your family were to come visit?
Brother doesn't have a license and my grandma's got health problems. She doesn't get a car.
Okay, so they just wouldn't come or he wouldn't let them come? You said that he would let them come visit.
He told me that they could.
They did not. Okay, so they did not come visit. All right, and speaking of license, that does bring me to the next question. When you first met my client, you didn't have a license, did you? You did? Okay. All right, and Jerome he took you to go get your license back when you did get it back, right? Okay, and at one point in time, you had a white Dodge Charger. Okay. But he had purchased that car. I mean, it was your car to drive.
It was his and he was just giving it to me.
Okay. And what about your online bank accounts? You had some online bank accounts like through Chime and other companies?
We shared one and then I ended up going back on my Chime.
Okay. All right, so I want to go back to the hospital. When you all were in the hospital, you said you guys played Uno together. You talked. Now, when my client, you stated today, or you testified today that he asked you for sex. Okay, and is your testimony today that you did not tell my client that you would do it one last time with him? You agreed, you told my client that you all could have sex one last time, right? Oh. And hold on, the one last time is because you knew that my client was filing for a divorce, right? You did not know that. Okay, but you had left the home and obviously did not have intentions on coming back. Okay. And after you all agreed to the one last time, isn't it true that my client asked you again whether or not this was consensual and that you were sure? Okay, but you said yes when he said that, right? Okay, and inside of this hospital, they've got call buttons next to the beds, is that right? They've got call pull cords in the restroom, is that right? They've got call pull cords in other places inside of the hospital room, right? Okay, so much so that I think you accidentally pulled one of those call cords at one point in the hospital, yeah. And pulled the wrong thing, okay. And my client didn't get upset with you or loud with you in the hospital, right? He did, and what did you do when he got loud with you? Okay, but when you were in the hospital, I'm assuming that doctors and nurses and orderlies or whatever the other titles I may be missing, they came in and out the room regularly, right? Okay, and there's no lock on the door inside of the hospital room, right? Okay. When did you report? You did not report this incident. You said that this happened on the 7th. Did you give us a date? I don't know if I took note of that. I apologize. You indicated on the 7th that this had occurred, but when did you talk to someone about it? On May the 10th. Okay, no, so let's just do this. When I ask you a question, just answer.
Well, what was your statement? It was on May 10th because
Work, I finally had a chance to go for a walk. And I was able to help someone.
you were able to go for, go ahead. Okay, so you're at the hospital, you went for a walk, and then that's when you told someone. You were still at Mott's at that point. All right, go ahead, Counsel.
Thank you, Anna. So based on what you're stating right now, does that mean that you never left the room? You left the room, the hospital room without Jerome, right? Yes or no? Okay, you left the room to go possibly get coffee? Yes, okay. You left the room to possibly go to the cafeteria, is that right? Okay, so all the food that you ate that day was ordered and brought upstairs to you? Okay. How about this walk that you said you went on the 10th? Had you not gone on a walk from May the 5th all the way to the 10th, the entire time you were there? Okay. You also—
You're saying that, I just want to make sure.
That's okay.
When you're answering no to the previous question, that meant you had not prior to that point in time gone on a walk, right? Okay. Yeah, I got it.
And the entire time you were in the hospital, you had your phone on you, right? Okay, but you had your phone on you. My client didn't confiscate your phone, either of the two phones that you have. You had both of your phones, right? And you talked to people on the phone or you texted people while you were there, right? Okay, but at some point while you were there, were you having conversations with people on your phone? Okay. You also reported, you testified today that your father's celebration of life ceremony happened while you were there, correct? Yeah, and you had someone come and pick you up, right? Okay, so how did you were able to arrange that ride with that individual without talking to them, texting them on the phone, or communicating at all? You communicated with her on the phone, okay. And there were times where you and Jerome had left the hospital together, is that right?
If the air mattress. Just he wouldn't let me stay in the hospital myself.
He wouldn't let you stay at the hospital by yourself. So you and Jerome went to go get the air mattress. He took you to La Casa as well, right? You did not go to the shelter at all during that 5-day period you were in the hospital? You don't remember my client driving you to La Casa and sitting outside for 2.5 hours while you went in there to check in? I can't hear you. Okay. How about, you don't have to do check-ins with La Casa when you're staying in the shelter? You had to do check-ins with them, right? And you were required to report to them to let them know your whereabouts and your well-being and things of that nature, right? Okay, and you did that on your cell phone, right? Okay. So you went to your father's going home or celebration of life ceremony. What day was that? Okay, it was before the 10th. So, but it was after the 7th, right? Okay, so your father's going home ceremony was after the 7th, before the 10th, so maybe the 8th or the 9th, right? Okay, and you went by yourself. That's what you testified to today, right? Someone came and picked you up and they took you to the celebration of life and you were there for however long that took and then you came back. Is that correct? Okay. And there were a number of times that Jerome left the hospital without you. Is that right? Okay, so there were times where you were there by yourself. He wasn't with you the entire time you were there, right? Okay, I don't have any questions. Well, give me 1 second, Judge. I do have a few more questions for you. Now, Jerome has never done anything to your son. Is that right? Okay, he's never abused your son, assaulted your son, or anything like that, right? Okay, and when you said that he tried to, or he told you that he had taken a number of pills,
What day was that? Okay, but it was sometime while you were in the hospital, right? And doctors and nurses and CNAs and other people walked into that room, right? And if you were really concerned about the pills that he took, you didn't tell anyone, you didn't report to anyone that he may have. Okay, so you didn't believe that he had done that. Okay, no further questions. Your Honor.
Any redirect?
Okay, Madison, how you doing? A few things I wanted to follow up on. So counsel asked you about essentially telling Mr. Burns that, you know, giving in, saying, I'll do it one last time. And you were saying that you agreed because you were scared. So you did it because you were scared. Can you tell us more about that, about what was going through your mind and what that fear was?
Say if I could, because we said because it was our anniversary that was the reason that we had to, because we were still married. Sure, it wasn't long.
And you asked if Mr. Burns has ever abused your son directly, Benjamin, and the answer was no. Has he ever assaulted you or done things to you in front of Benjamin? Okay. Please tell
Your
the.
Honor, I want to object to that. I think that this is still leading towards the out-of-county offense.
Well, actually, you raised the issue. I think you've opened the door to that regarding abuse. So if a parent something is happening to a parent in front of a child, that might be considered abuse. But I think you opened the door by your question. So objections overruled. You may continue.
Thank you. Please tell the court about that abuse in front of Benjamin.
Did anything sexual? Yes, we had to stay home. Whenever we would do stuff like during the night, it's obviously, but then we would get frustrated and we would start crying. We were doing stuff.
Okay, and what would that frustration look like?
Frustrated, I think, calm down, fast, tell me that I wasn't telling him to quit or something.
So Mr. Burns was telling you that you're not saying no?
Telling him to quit. He doesn't comprehend words. He might say a couple words, but he doesn't know like meaning.
Okay, so Mr. Burns wanted you to tell your son to quit crying. Is that what? I'm sorry, I'm not understanding. Okay. Okay, and he was frustrated that you wouldn't say that. And when Mr. Burns would have sexual contact with you, when he would sexually assault you, the times that it was against your will, was Benjamin in the room also? While you were at the hospital between May 5th and May 12th, you started kind of getting into, in response to some of counsel's questions about the times that so sometimes you were able to leave the immediate hospital room. Could you tell the court more about how that happened? When were you allowed to leave? Were there conditions put on that?
Just
And I kind of want to, we're asked a lot of questions about when you were around other people, when you were around from Mr. Burns. And I want to kind of group them all together. Could you tell the court the best you can why during those times, if you felt comfortable telling them and disclosing about the abuse you were going through? You were in the hospital for a few days, but was it your understanding that at some point you would go home or return to the shelter, I believe, at the time? Did you have concerns about what would happen if you had reported assaults at the hospital? Sure. With the understanding that you were going to end up having to leave the hospital, did you have concerns about what would happen if you reported to hospital staff about the assaults? You said that on May 10th, you finally did report the assault. Could you tell the court about the circumstances that came about?
I wanted to go for a walk, make a phone call, just to get like me.
Okay.
And then anyway, she like, in the corner, I see them storm out the other day for the elevator. I thrown the bed.
And what did you do, if anything, at that point? Okay. Did you go back to the room? Who did you end up reporting it to? Okay. And how come you felt like you could report it at that point? You testified that he had told you when you got to the hospital to shut your phone or phones off, but at some point you were able to turn them back on to make calls.
I think I told him that I needed to at least do check-ins. Certain people.
So he let you turn the phones back on. One moment, Your Honor, if I may. Madison, you're asked about having two cell phones. How come you had two phones?
Got another one because won't let me touch my phone. So I needed to get hold of somebody for emergency. So I had another phone stashed that way. Outside or two. Get through.
Thank you. Nothing further.
How long had you had the second cell phone? From, well, hang on. When you say a few weeks or months, is that from the April 4th date or from the May date? From which date? April or May?
Back to March.
Somewhere. Okay, gotcha. All right. And when you use the word, you said you had it stashed. Where did you keep that phone? Say again? In your desk? That was at the apartment. Okay, so you kept it somewhere around there. So when you talked about, as you testified, that he told you to put your phone up on was it dresser? I think it was. Was that both phones or just the one phone? That's what I was getting at. So the second phone, he did not know. So you wouldn't make calls on that phone? Just had it in case. Pardon?
Service on it, but I wasn't able to yet, so I was trying to figure out a way to.
Say that again for me.
Try to put service. So, I was trying to figure out how to be able to do that.
So when you say this other phone, when you're talking about putting a service on it, a plan, okay, that's what you're trying to do. So when you first got the phone, prior to you doing that with Kroger and everything, could you call from that phone? Got it. Okay. So you had to, when you had that phone, you could make a Wi-Fi call, but you couldn't make a cellular call. That makes any sense to you, but it does to me. But you think you could call from that phone as long as you had Wi-Fi access? But what you were trying to do when you were talking about putting a plan on it, you wanted cellular service. Okay, if I'm probably getting way too technical, but you wanted service like everybody else's phone, or right? I mean, not you just needed a plan so you could call from any, basically, if you needed to.
I wasn't sure if I was going to be able to call it out.
The plan, got it. Any questions based on the court's questions? Second.
I have a few, Judge.
Go ahead.
You, your son's on Social Security disability, right? Okay, and you get money monthly from the government for that? Where does that money go? Into your account? Okay, but you, okay.
Or in my account, we had to put in his, business account.
Okay, but you were receiving money. I'm gonna,
Hold
and
on.
the reason that I'm asking that, Judge, if I may, is because she just testified that she needed to get out of the house to put money on her card because she didn't have any money on her card. So her testimony is as if the only.
Right, but if you, just my understanding, hang on. My understanding of the time frame is that she doesn't have this other account of hers until after she leaves on the 4th.
I don't believe that's the case. Is you, I don't.
Go ahead.
If the court can ask.
But I don't think I had, that money at that time. I think it had already ran out.
What had run out?
Per month, for vitamin.
Okay, so when did that start going into an account you had?
Past year.
Okay, but before then it was placed where? Did you have access to the business account?
Then I don't have any further questions.
Anything from the people? All right, Madison, you may step down. Thank you.
Your Honor, may this witness be excused?
Any objection?
Judge, I know that it won't be convenient because I'm sure that, I know the people had inquired earlier about child transportation and childcare. I would love to be able to call her as a witness, and depending on what testimony comes out later, I don't want to be unreasonable though and say, no, she can't be excused. So I don't know.
Okay, what's her scheduling like at this point? Hey, and here's the reason I'm asking. I've got a docket as a informed counsel that was actually supposed to start at 12. I pushed that back to 1. That portion of the docket to 1. I have to get on that docket and try to do that. So I'm going to have to take a break if that's going to work with transport, because I know that here you've got to get the 3 that I have. Okay. So I'm going to let, so here's what time is it? Thank you. Like Alexa. Anyway, what I'm going to do is we'll reconvene at 2:20. Well, just make it 2:30.
Okay.
To continue this exam, if that will work for everybody.
I'm not sure, Your Honor, I will, if you wouldn't mind checking.
I can check with the social.
Yeah.
Officers can stay.
Yeah, I will.
They were 10 to 8.
Yeah, Your Honor.
So did I. No, go ahead.
Your Honor's energy is unmatched, I'll say. Your Honor, I would suggest an adjournment at this point. I would like some idea of what potential, I know we can't predict what the testimony may be, but in what scenario we would bring the victim back. We can do it at a different time, but at this point, I think that adjournment would be more appropriate.
Second, really. How many more witnesses do you have? I had 5 listed, 5 others listed, but I think you had 1 struck off that. So would I have 4 more?
So Your Honor, yes, we have a social worker and 2 officers, so 3 more.
3 more. Okay. Ms. Ackenrode, how do you feel about the adjournment? I have no
Your
idea.
Honor, we would be objecting to the adjournment. We are ready to proceed. I don't know, again, the line of questioning that may bring rise to having to call her back. But I think that if anything, we could adjourn that portion of it if need be. But I know the court is obviously has to jump on this other docket, but we're here all day and ready to proceed once the court is done with the original, with the other docket.
Well, let me just say this. Part of the reason the court's in the time position that it's in is because the court was out at 9:07 ready to start. There was some delay in terms of talking with the witnesses. I'm not going to call it a delay. Prosecutor had to talk to some of the witnesses. There then arose an issue. You had to talk.
Absolutely.
And I didn't get started till whenever, trying to give leeway as best I could to the parties so that they could be prepared. Oh, let's do this. There are 2 officers? Is that part of the difficulty is the timing of the officers and their?
I think the officers, we also have to check on the victim regarding childcare.
Okay, let's do this. I'm gonna give transfer time to go get my people for that docket. I'm gonna have him taken back and then we'll figure out if we're gonna proceed, but I gotta start moving something at this point, okay? So court is staying in recess.